pedal to the gas, we're watching it all. Covering the courtroom, big case or small. Laugh when we can, cry when we must, but it's all real talk, you can count on us. We're not the pros, just fans who care. With popcorn in hand and a comfy chair. And every twist, we're right there. Together like we're all in the witness chair. This is the Broken Baker, where the trials come alive, where the chat is wild and the vibes survive. We're watching the worst of what people do, but we keep it light, yeah, that's our truth. It's the only place for crime, and it feels just right. We bring the justice talk into your night. So hit that stream, don't miss the call. At the Broken Baker, we cover it all. Oh yeah. We're just laymen with the view, but we ask the things the world wants to. Digging through the facts, side by side. Even when it's dark, we bring the light. No clickbait, no fake feels, just truth and the highs and the reels. With the chat that roasts and rises, we're just here for the case and the vibes. This is the Broken Baker, where the stories unfold with a smile in the heart, even when it's cold. Yeah, we cover the bad with a wink and a grin. Where the real talk starts, come on, jump in. It's the only place to be, can't you see? For trials and truth, it's BBTV. The Broken Baker, where the trials come alive. Yeah, we'll be here, trial of the trial. Yeah.
I love your song. I was just glad you weren't the Broken Joker, because then it would be BJTV.
I've been up since 4 a.m. this morning. I've been on the
So
road all.
have I.
Yeah, but
I haven't
your
been on the
4
road.
a.m. is 6 hours later than mine.
Math is a weird and strange thing, and I
Your
don't
4
approve
a.m.
of
is
it.
my 10 a.m.
Well, I know, but we
So
still got up at our relative 4 a.m.s.
yeah, I just stayed up 6 hours longer, so I wasn't ready for that comment. Hey everyone, welcome to closing arguments in the Raul Valle case. Sorry we're a little bit late, but everyone apparently went on holiday today, so traffic was a little bit of a pain in the behind. And I was lucky that I could get home to myself. I took Monty for an hour walk, and then I drove home, and hopefully he's happy now. He did get to go whatever he needed to go, so that's I did what I had to do. But it's a little running in here, hitting the on, and then just opening all the screens and go. You don't have your normal.
Yeah, and your heart's racing. You're like, daggone, and then you get all fat fingered, and you can't. You're like, damn it, backspace.
Yeah, where's my drink I normally have? And well, when it gets started, I can go get ready. And it's going to be interesting to see that we haven't heard any time limits. They might say that before they go. If there is a time limit, I could have a sneaking suspicion that the defense will drone on for a very long time. He seems to be good at that. But not much fact and evidence. I still think because of the poor defense, they will get him for murder, which I think would be too much for the crime.
Can you give me like a 5-minute elevator pitch about what this case is about?
I need a demonstrative, because this
Okay,
is
okay. Ooh,
actually
pictures.
quite weird of a case. 2 kids arrive at party A, where the defendant and his buddy starts a fight with them.
Okay.
So those 2 kids leave that party and goes to a girl's house. The
Okay.
defendant and his group goes to a high school. Then
Okay.
these people go to the rich house. While they
Okay.
are at these two places, they start being tough guys online. And the defendant, even though he couldn't remember he ever said that, said, "Give me the address and we'll show up." So they go to the rich house where they are surrounded by 30 kids or 15, something like that. It's a
Okay.
little. So they drive off. They drive off and lets people out of the car. The defendant is out of the car, is talking to his girlfriend about driving with her home, but someone chucks a knife after him. He picks it up, gets back in the car, and drives back to the Ritz house, where they then leave the car, him and one other guy, gets into a fight. He slashes 3 people. And the big problem is when he claims he started swinging because he was afraid his body was going to get killed. But the guy he unalives, we see a video. There's a short video where you can't see anything. But in that video, his body is here. The rest of the people are on the grass over here, where the victim and the defendant are next to each other, and the defendant stabs him. So he is not in defense of his body.
No,
He
he
doesn't
would be
say
in
that.
defense of himself. I mean,
Yeah,
if we're going
and he doesn't say
self-defense.
that. He said he only stabbed because he was trying to help his body. So that's going to be the problem for me.
Ooh,
I think there's enough
lawyer
to say
man bun.
manslaughter, but I think they're going to get him for murder. His defense lawyer has a ponytail.
Good morning, Your Honor. Mark Durso for the state of Connecticut.
Good morning, Your Honor. Tatiana Messina for the state of Connecticut.
Good morning, Your Honor. Kevin Smith for the defendant, Raul Valle, who's at my side.
So,
Oh, and his defense team, he had one lawyer who is apparently in some trouble himself or was removed from the bar or something. But before he Ponytail left his office, and this guy fired his original defender and took this guy. And this guy is about the worst. He didn't ask any questions, so you were all swarming in on him. You were all fighting, so you could put up a self-defense. It sounded like he was making a "I didn't do it" defense. And then all of a sudden, it was in defense of other self-defense.
I'm not a lawyer, but you would be defending yourself.
Well, you can say it's self-defense of others. If he's afraid his body is about to die, he can't. Well, he can use a weapon.
Well, but the more imminent threat would be the person right next to him. So if his other friend is away from the group, I mean, I do realize that, distances can be shortened in a long or in a quick time, but it's a little confusing.
It's very confusing, and I don't think anyone really have figured out how his defense is going. But he talks a lot. And oh, by the way, the 2 other guys who were in the car both have immunity deals with the state, which makes it no less sus.
New England, do better.
Yeah, sadly, we know them too well.
court would just like to note for the record that the court did prepare a draft jury charge, which was presented to counsel for review. Prior to closing arguments this morning, the court did have a brief informal conference with counsel regarding that particular jury charge, which will be marked as a part of the minutes and put in the court file as a draft copy of the jury charge. I do usually go through each of the sections just to determine whether or not there are any questions or any changes or requests that have not been made to the charge in accordance with anything submitted by counsel. So I'm first going to start with the state and ask the state, did you have an opportunity to review the draft jury charge that was provided to counsel?
The state has had an opportunity to review the draft, Your Honor.
All right. And let me just ask for which court exhibit this would be in terms of referencing for ID.
It would be exhibit number 3.
Right?
Court, yes.
All right, so this is court exhibit 3 for ID. All right, and then I'll move over to the defense. Attorney Smith, have you had an opportunity or ample opportunity to review the proposed charge in this case?
Yes, Your Honor.
All right. And so I'm just going to go through sort of each of these sections to make sure that the court is not missing any argument that wishes to be made on behalf of the charge that the court intends to provide to the jury in this trial. So we're going to start with the court's duty to instruct and function the court and jury counsel. Any changes or requests that you're looking for regarding those sections?
No, Your Honor. Nothing from the state.
None from the defense, Your Honor.
All right, moving along to presumption of innocence or in the proof and reasonable doubt. Any changes or problems with the charge that you make with this?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right, thank you. Going forward, evidence direct and circumstantial evidence, are there any requests, changes, or comments that you wish to make on the record?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
Redacted exhibits, I know that counsel is of the opinion that there aren't any redacted full exhibits in this trial, so I will be changing that language to accommodate that concern. So it's basically going to read, if there are any exhibits that have been accepted into evidence as redacted versions of the original, please note these redactions were made by way of agreement and the charge will continue. Is there any comment or concern regarding the court's change to that section?
Not from the defense, Your Honor.
Nothing from the state, Your Honor.
Okay. All right, moving forward to credibility, any questions or comments regarding that section of the proposed charge?
No, Your Honor. Nothing from the state.
Not from the defense, Your Honor.
Witness, witness cooperation agreement. Any
No, nothing.
concerns?
No concerns from the state, Your Honor.
Not from the defense, Your
All
Honor.
right, and just to confirm, those appear to be states exhibits 94 and 96 with respect to Jack Snyder and Tyler Discover respectively, is that correct?
Yes.
Yes, Your Honor.
Thank you, sir. All right, testimony of police officials and expert testimony. Any questions or comments?
Nothing from the state.
Not from the defense, Your Honor.
All right, court has inserted Dr. James Gale, Dr. Ryan Joss, PA Eric Clark, and Dr. Rizal Combi. Those witnesses please stand and provide opinion relative to certain conditions, certain results, and certain definitions and approaches of certain standards. So is there anyone that should be included here or anyone that you feel should not be included here?
I don't believe so, Your Honor.
Not from the defense, Your Honor.
Thank you. Defendant's testimony and proximate cause, anything on those two subsections?
Nothing from the state, Your Honor.
Not from the defense.
All right, specific intent, I know they went through these, but I just want to make sure that we have this right and that the court is charging with respect to the intent required to be proven by the state relative to the charges. I want to go through it. So count 1, murder and man in first degree intentional as lesser included. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Count 2, assault in first degree intentional and assault in second degree intentional as a lesser included. Correct?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Count 3, assault in first degree intentional and assault in second degree intentional as lesser. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And lastly, count 4, assault in second degree intentional. Correct?
That's correct.
Yes, Your
No other charge contained in any of those counts that you believe requires counting a specific intent.
No, Your Honor.
No, Your Honor.
Moving forward to recklessness, any changes or comments?
Nothing from the state, Your Honor. Other than with regards to the concept of recklessness, just so the jury is aware that it is a lesser included offense to count 1 and not yet.
Thank you. So we did discuss that in our informal briefing on this charge, and the court has made that change on the charge that you will get and that will be going to the jury. So it won't have an opportunity to review that again. So I just would like to go through the concept of recklessness to make sure that we are all on the same page as to the specific mindset that has to be driven by the state relative to charges. Count 1, manslaughter in the first degree, reckless as a lesser included.
Yes, Your Honor.
Yes, Your Honor.
Count two, assault in the first degree reckless as a lesser included. And
Yes, Your Honor.
assault in the second degree reckless as a lesser included.
Yes, Your
Yes, Your Honor.
Thank you. Count three, assault in the first degree reckless as a lesser, and also assault in the second degree reckless as a lesser.
Yes, Your Honor.
Yes, Your Honor.
And lastly, count four, assault in the second degree reckless as a lesser.
Yes, Your Honor.
Yes, Your Honor.
Evidence of intent and motive, anything under those sections you'd like to discuss?
Nothing from the
No,
state.
Your Honor.
Consciousness of guilt, has everyone had an opportunity to review the state's claims, any concerns or questions or comments that anyone would like to make?
No, Your Honor.
No, Your Honor.
Identification of the defendant, any questions? Concerns?
Nothing from the state.
Not from the defense.
Specific charges brought by the state, again, the court will be modifying the charge to include substitute information as opposed to just information. I will be providing additional bills and highlight the substantively. Is there anything regarding first the introduction to the specific charges that you'd like to discuss?
No, Your Honor.
Not from the defense.
All right, and again, as to each of the four counts, when we discuss elements, even on the lesser included, I will be direct.
No, it sounds like they have an air condition that's that needs some VD40. Oh, WD-40 is a big part in it because he got sprayed in the face, in the eyes with WD-40, and still just ran up and participated in the fight because that doesn't hurt at all.
Which teenager was carrying WD-40?
Well,
'Cause
it
I
could
need
also
this
have been
story.
some foam. They don't really know, but someone sprayed him with something in the eyes. We don't use double V in Denmark. That's why everything is V. If it says a W, we will just say V. Because we have it in our alphabet, but other than VC, we don't use it for anything.
Okay, what do you call a watermelon? A
Vandmelon.
watermelon?
Vandmelon. We have our own language. It's called Danish, so we just have other words than Americans have.
Oh, I just figured everyone spoke English.
We call it a watermelon, but water is spelled with one V, V-A-N-D. That's
So wait, in
water.
Russia, do they call it a vodka melon?
Only if you put vodka in it.
I knew I had something on my to-do list today.
You haven't? You never spiked a watermelon?
No, I actually don't drink as much as I joke about.
Yeah, vandmelon. He also says vegetable. Ginger with a soul is just happy because they have talked a lot about big red bushes in this case. So she has been, I feel represented for once.
So does Kathy Griffin. I didn't know that the Queen Elizabeth, the first look was in, but
Yeah, I saw that picture. I showed it to the guys when we did the night show. Ooh.
she is responsible for sterility in an entire generation.
I'm just thinking there might be an It 3 coming up.
Don't disrespect Pennywise like that.
Yeah.
Or elements that must be found as well.
Yeah,
So
that's how we say
would
vegetable.
Count one murder, anything substantively under that count that you'd like to discuss.
Nothing from the state.
Not the defense, Your Honor.
Lesser included offenses to murder, we'll start with manslaughter in the first degree, intentional, anything about child, you'd like to discuss substantively there.
Nothing from the state.
Not from the defense, Your Honor.
Manslaughter in the first degree, reckless, anything substantively you'd like to discuss there.
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, and it's my understanding that those are the only two lesser included offenses the state has protected, is that correct?
Correct.
And nothing from the defense, correct?
That's correct, Your Honor.
Okay, good, thank you. All right, please, let's move on to count two then, assault in the first degree, anything regarding assault in the first degree intentional.
We are all
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right, lesser included offenses to assault in the first degree intentional.
Penilla, remember they are Americans. They wouldn't like Usu because Usu kind of tastes like licorice.
Wait, licorice and watermelon? Okay, that's a Geneva Convention thing right there.
It tastes good. It tastes good.
I will try it once. I don't know if I can find ouzo in America, but I will try it once. I tried Malort, and that was sadness and liquid Band-Aids in a bottle.
You just have to drink like 10 or 12 of them, then it tastes fine. I'm gotten used to it now.
We'll start with the introduction and from there. That you'd like to discuss.
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
Thank you. All right, first lesser included assault and first degree reckless, anything substantively there.
Nothing from the state.
No, Your Honor.
Second, B, assault and second degree intentional, anything substantively there.
Nothing from the state, Your Honor.
No, Your Honor.
And moving on to C, then assault and second degree reckless, anything substantively.
This isn't even.
State sees none, Your Honor.
This is how a normal case is, and that's the thing. Most cases are really boring.
Yeah.
If and only if they have found.
Now, is the defendant well off?
So I just want to make clear that.
He went to a well-off school.
The only
Okay.
offenses that have been requested on behalf of the state include assault in the first degree reckless, assault in the second degree.
Uso is Greek. You might have had the snaps. That's what Danish people normally will put in the face of foreigners, and will laugh at you after. But that tastes of like cumin. That's the devil's drink. You only drink it at Christmas, and you'll get in a fight, or you'll have a baby. There's only two options when you drink that.
I'm staying away from Denmark in Christmas because I don't want to do either.
Yeah.
Intentional and assault in the second degree reckless, is that correct?
That's correct.
And nothing from the-
Not from the defense, Your Honor.
No, I think they just stood up.
Great.
They sat down to
Assault
begin
in
with.
first degree intentional as to a different victim, junior, anything substantively under that.
Jägermeister is
Nothing
pretty
from the
good.
state, Your Honor.
Not from the defense, Your
And
Honor.
I will, of course, get some sound on the defense, the different possible. All right, so I have the same lesser included charges on count 3 as I did on count 2.
He is 19 now. He was 16 at the time.
Okay.
Charged with an adult because of the
Nothing
severity
from
of
the
the
state,
crime.
Not from the defense.
Okay.
60 years minimum.
All right, and the same question, same lesser included offenses, were there any additional included offenses that the state has requested?
No, Your Honor.
And nothing from the defense.
Nothing from the defense.
Moving on to count
Yeah,
4,
don't put it in
assault,
cheese and don't put it in my drink.
non-habituated rape. Is there anything substantive or any kind that you'd like to make regarding that particular count or that it's silent?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, and then we have lesser included offense for assault second degree intentional, and one lesser included that includes assault second degree reckless, everything else.
Nothing from the state.
Not from the defense, Your Honor.
And just to be clear to the record, the state did not request any additional lesser included.
That's correct, Your Honor.
And nothing from the.
Nothing from the defense, Your Honor.
All right, moving on to self-defense, defense of others. There will be some initial direction to the jury concerning an independent and separate determination to be made as to each of those defenses as they're separate or whether related. Aside from that, is there?
Hey, James, there.
Under self-defense or defense of others that I would like to address.
Nothing from the state.
Not from the defense, Your Honor.
So I will note that I did receive, let me just get, no, let's do this session. I did receive state's request to charge on combat knives in the plan, so the state is kind of.
I'm going to withdraw that question charge, Your Honor.
All right, so no, moving forward to sympathy, well, obviously, as complainants, we got this of people in the last sentence and persons, any changes there?
Nothing from the state.
Not from the defense, Your Honor.
Hey, implicit bias, citizen harm, retiring, anything there?
Nothing from the state.
No, Your Honor.
No taking anything there?
Nothing from the state.
Not from the defense, Your Honor.
So where it says you may only deliberate on all 12 years of the jury, from there down, I do intend to add an additional subsection in closing. Any comment?
No objection to that.
No, Your Honor.
Is there anything that the court has been requested to charge and the court has not charged that you would like to discuss?
Nothing from the state at this time, Your Honor.
Not from the defense, Your Honor.
All right, and is there anything that has been contained within the charge that either of you take objection to at this point or request further arguments?
No, Your Honor.
No, Your Honor.
So the court is wrapping up some intergraphical error corrections on the.
I think that his defense is more likely to send him away for 6 years. I believe that a manslaughter charge would have been appropriate because, again, the first couple of guys, they are in a fight and he starts swinging, which is wrong, which is assault. I can accept that. I have a problem with his body being away from the fight and he stabs the last one. But in the heat of the moment, and I don't think he wanted to unalive anyone. I think he just wanted to stab or swing at someone.
Yeah, I mean, also, were they all under the influence, and was there a
No,
plea
everyone
deal?
had 2 beers. Only 2 beers. One had three. And there was a guy who was looking for chicken nuggets.
Okay, y'all, I don't know if this hasn't been disseminated, but if you are a functional alkie, the number of drinks that everyone says that they have is always 2. They're like, you're officer, I had 2 beers.
No, I have a cataracts. That's why I have to drive like this. It's not because I'm drunk, the officers.
Look, officer, when the world stops spinning, I will totally do the, sober hokey pokey, the dance of sobriety.
Yeah, we don't have that. We just blow or have a blood draw. We don't do all
Oh
the
my
dancing.
God. Baker, I figured it out. Did he only get 1 dipping sauce for his nuggets? Because that makes me extremely mad.
It wasn't him. It was another guy who will. When they drove up to the party, he went out and looked because he had heard they had McDonald's. Yes, he was.
Damn, now I want
he
chicken
was
nuggets.
he was a rather large guy who probably played O-line on the football team, and he was just like, I heard they had McDonald's.
To be fair, that might be my spirit animal at a party. Like, hello, I heard there would be cake.
Yeah, but I like that guy. And then he started
Charge
lying.
itself,
Didn't
or is
like that.
almost done with that. Before the court charges, you will of course have an opportunity to review that to make sure that it is in accordance with the changes that have been suggested and will told you that would be made regarding this charge. Before we begin closing arguments, would you prefer to have a completely amended jury charge? That's up to you. I'm happy to do that and provide that to you before we start closing.
The state does not require that at this time.
Defense doesn't need that, Your Honor. Thank you.
And then my last question would be, would either of you like to take a few moments to either gather exhibits or make yourselves comfortable as well, and gather your outlines for your closing arguments before we proceed forward with those closing arguments?
The state's prepared to proceed, Your Honor.
Closing arguments on behalf of the parties. State will have the opening for first argument concerning closing argument, and the defendant will have an opportunity to also make an argument to you, and then you will hear from the state again, perhaps. It's my understanding that you will hear from the state a second time as the case. Now, although the state has 2 arguments, both sides get the same amount of time to present their argument to you. That time is a total of 1 hour. The state gets 2 opportunities to present to you because the state does have the burden of proof in this particular trial. So we will hear from the state, we'll hear from the defense, and then we'll hear from the state again. There may come a point in time where I have to interrupt defense counsel if timing is off a little bit. So please don't hold that against anyone. That's my fault. So I hate to interrupt, but I might have to. All right, we'll see how the closing arguments go, and then we'll decide what we're going to do about it on that. Thank you so
Does her mic not function?
as well as your attention to this
I
particular
have it boosted 10 times. If I take the boost off,
No, I
This is what
know.
you're
It
hearing.
just seems like it's not plugged
during
in.
closing arguments. And the reason that I do that is because closing arguments are not evidence. Number one, the attorney's stating is not evidence. So you've heard the evidence that you're going to hear in this case. This is the opportunity for counsel to argue to you. So I won't have you take notes during this time. I would ask you just to pay attention to counsel, listen to their arguments, and then I'll have an opportunity.
yeah, they at least knocked it out of their hands.
Good morning, ladies and gentlemen. So I was actually just going to address that arguments are not evidence. This is
I'm going to get a
right.
drink.
You've heard all the evidence that you need to hear.
Okay, dokie.
At some point in time, you're going to decide this case based on what you heard in court. But I wanted to take a moment to thank each and every one of you for giving us your time. It's been 2 weeks, over 2 weeks. All of you have listened diligently. You've given your time. You've given obviously your lives outside of this court are more important. But this is a very important civic duty, and it does not go up unrecognized. So we thank you very much. As the court indicated, this is my first of 2 opportunities to talk to you about this case. And in this case, there have been many witnesses who testified. This happened 3 years ago. They provided different perspectives on what they saw, what they heard, what they did. And the majority of the witnesses were teenagers when this happened. It was a horrific event. But the main story is the same. The main story is the same. The horrific event that was etched in their minds was the same. This case is not about who did it, what happened, how it happened, when it happened, what happened. This case is about Raul Valle, the defendant, who brought a knife to 43 Laurel Glen on May 14th of 2022 and provoked a fight and stabbed 4 kids
9 times, killing 1. That's what this case is about. So what happened on May 14th of 2022? You heard testimony about this party at Lazy Brook, where it was a St. Joe's party. Kids were hanging out. They were drinking. Typical high school party. Probably not the first time there's been alcohol at a high school party, right? Not that anybody's condoning it, but it happens. So there's this party. The defendant's there with his friends. He's wearing this helmet. And in come in some Shelton High School kids, Ryan Hines and Griffin Marcinzik. And because this is a St. Joe's party, not Shelton party, they can't come in. So the defendant and Mr. Snyder and De Silva take it upon themselves to kick them out. They steal the beer from Ryan Hines. At some point in time, it gets heated. They're arguing back and forth. And at some point, it ends out into the driveway. And when it's out into the driveway, there's this agreement. I'll fight you for my beer. So Jack and Ryan square up. And just as they're squaring up, who starts the fight? The defendant starts the fight. He sucker punches him in the back of the head. And then after he sucker punches him in the back of the head and the fight goes to the ground, he takes his helmet and uses it as a weapon and slams it into Ryan's head. You heard the defendant testify. He would have to believe that that was a push, that he pushed Ryan Hines and that he didn't hit him with the helmet. I would submit to you that if you watch that fight, you could judge for yourselves what you see in the fight.
Was it filmed on a Casio Speak and Spell?
And by the way, while I'm talking about witnesses, the judge is going to give you a credibility instruction, right? You're all going to have to assess the credibility of each and every witness who testified. If you recall during voir dire, I think I asked each and every one of you the same question. You think it's possible that somebody could get on a stand, raise their right hand, and tell the truth? And you all said yes. I also asked all of you, do you think it's entirely possible that somebody could swear to tell the truth, believe they're telling the truth, and simply be mistaken about something? And you all said, yeah, that's possible. But I also asked you, do you think it's possible somebody could get on that stand, swear to tell the truth, and look all of you in the eye and outright lie to you? So again, when you're assessing the credibility of each and every one of the witnesses who testified, that's what you have to go through. You have to go through what they said and how does it line up with the rest of the case, right? The defendant who took the stand is also subject to that same credibility instruction. He put his credibility in issue as soon as he took that over. The video I would submit to you tells a very different story than what the defendant testified to a couple days ago. So after this fight, they get in Jack's car and they leave Lazy Brook and they go to Trumbull High School. And at some point in time, as they go to Trumbull High School, there's this basketball group chat. You heard testimony that Shelton kids were in it. You heard testimony that Ryan Hines was in it. You heard testimony that the defendant was in it. You heard the testimony that De Silva and Snyder were in it. And you also heard testimony that they wanted to fight the Shelton kids at Trumbull High School. They were there for about 20 minutes. This wasn't over. Of course, there was argument and heated emotions about what had just happened at Lazy Brook, but now they want to meet up at Trumbull High School. So what does the defendant say? The defendant tells them to slide on over to Trumbull High School multiple times in the group chat. Slide right over because they want to fight. Shelton kids don't want to go to Trumbull High School. Somebody puts an address, 43 Laurel Glen, in the group chat. Come to Laurel Glen. So they go over to Laurel Glen. The defendant would have you believe that he had no idea that they were going to fight, that they were just going to another party. I would submit to you that you need to assess whether or not that's credible during your deliberations. But in any event, you heard testimony from several witnesses that the defendant wanted to go to Lazy Brook or Laurel Glen to fight. He wanted to fight at Trumbull High School and he wanted to fight over at Laurel Glen. And that's why they were going. And as a matter of fact, when they got to Laurel Glen, the defendant lets all the kids know that they're there. There's a few kids outside, more kids come outside, and at some point in time, Tyler Rich and his friends are outside. They're around the car in front of his house at 43 Laurel Glen. And there's some testimony that at first it was peaceful, some testimony that it got heated, arguing back and forth, things were being thrown. You heard testimony from Aiden King. I saw Raul sitting behind Jack Snyder, who was driving. Tyler De Silva was in the front seat. The defendant even said Aiden King's his boy. And Aiden King got up here and said, at some point in time, the defendant said, "Get your friends away from my car. I'm going to break a bottle over somebody's head." Again, all of these things going to what was his intent that night. So things are thrown at the car. The car was being shook by the Shelton kids. There's some testimony that things were being thrown back. Car takes off, drives up and down the street. Things are thrown from the car, things being thrown at the car. At some point in time, they end up at the end of the street, close to the intersection of Farmhouse Road near 36 Laurel Glen.
I can see people say it's too fast. And then he takes a break for an hour.
Now, this is 11:40 at night. You heard testimony. This is Jack Snyder's car. The defendant's already out of the car. Tyler DeSilva gets out of the car. I would submit to you that the defendant being mad, angry about what had just happened, Jack Snyder's car, happens just prior to this video starting. And that's the point when he asks him for the knife. He asked him for the knife. He said, Jack, give me the knife. Where's that knife? Give me the knife. He gets out of the car. Tyler DeSilva gets out of the car. Keenan, Dimitri, Will, Mackenzie walking away, everybody with an earshot of that conversation. You heard people testify about what they heard about the knife. How you heard Keenan Frasick, he was going insane. He was pissed off about what happened, what had just happened to the car. You heard Dimitri, he was angry about what had happened to the car. Tyler DeSilva, Jack Snyder. You heard Mackenzie say, I heard somebody asking about a knife, but I don't know exactly who it was because she's walking away, right? So we know the knife comes out at that point in time. He's angry. He arms himself with a knife at that point. But then the Shelton kids come down the street after having just told them, get out of here, get the heck out of here. Now look, was it right that things were thrown at the car? 100% no, was not right at all. Wasn't right that people were hitting the car, shaking the car, and people throwing things from the car at the kids or at the cars parked on the side of the street. That wasn't right either. But at that point in time, nobody called the police. They drove down the street. Could have called the police at that point. Could have said, hey, someone just damaged my car. I want them arrested for criminal mischief. They didn't do that. The defendant at that point in time thought it was very important to arm himself with a 3-inch bladed knife at that point. So the kids come down the street. You heard Tyler Rich, Charlie Connery, Ty Wood, Ricky Fiola, a few other kids go down the street. And yeah, there's things thrown at the car. They throw things back, right? But there's no physical altercation between the parties down the street. Because if there was going to be a physical altercation initiated by the Shelton kids, it would have happened right then and there, but it didn't. Right? Again, Tyler Rich running down the street. Get out of here. You guys got to get out of here. Now, you heard some testimony that somebody threw this can of WD-40 or PB Blaster back at Tyler Rich, and he's walking away. And at some point in time, he sees the defendant, and the defendant's walking towards him. So he sprays him to get him away. Ricky Fiola sees this. He's within a short distance to see this happening. At some point in time, Ricky Fiola approaches the defendant and has a conversation. And what did you hear him testify to? He said, listen, hey, man, it's really messed up what he did. He shouldn't have sprayed you with that stuff. But look, there's a lot of us, and there's only like 5 of you. You guys should probably just get out of here. And while he's having that conversation, what does Ricky Fiola see? Ricky Fiola sees the defendant holding a knife in his hand. Ricky Fiola turns around, walks back. The rest of the Shelton kids walk back to Tyler Rich's house. Again, no physical altercation down the road. Mackenzie Traficante is calling her sister, I need a ride home. At some point in time, Will, Dimitri, and Keenan get out of the car. And they don't want to be a part of anything. They want to ride home. They stay down the end of the street. Rides are being called. Will calls his girlfriend, come pick me up.
Best name.
I think you heard testimony from Mackenzie Traficante, who said, no, Lito, just stay down here. Stay with me. Come home with me. That's not what he wanted to do. Because Ryan Hines, who he had just sucker punched in the head earlier that night and helmeted back at Lazy Brook, who was now at this party, now he wanted to go back and face those kids. But he wasn't going back just him. He was going back with a knife. Because who else goes back to a house, right? I mean, you heard testimony when he was in the car with a bunch of other people, and the car was being shook and rocked and thrown at, that he was panicked, he was frightened, he was scared, he was terrified. If you're all those things, why are we not staying down the road? Why are we not waiting for Mackenzie's sisters to come pick us up? Why are we not calling somebody to come pick us up? Because he wasn't scared, terrified, panicked. It's simply not, that's not the case. He was mad, he was pissed, he was angry, and he had a knife. So they wanted to go back and go and confront those kids. Now there's some testimony that Tyler wanted to go talk about the damage. and he knows Tyler Rich. Maybe he could work something out. But the bottom line is, he's the one that was going ballistic about the car. Yeah, sure. Tyler and Snyder were angry, but he's going crazy, and he's the one that arms himself with the knife. So he gets back in that car. He makes the willful decision, right, to get back in that car, armed with a knife, and go back to the very house he was told to leave. But he would have you believe he was panicked, scared, frightened, all those things. So Jack pulls up to the 43 Laurel Glen. The defendant and Mr. De Silva get out. You've heard testimony from several witnesses that Tyler's on the left, the defendant's on the right. They move onto property. They were told to leave, so now they're trespassing. Some kids were outside. Got a little bigger when people heard, oh, people are here. You heard Tyler Rich say, I told him to get the F out of my property. The defendant walks up. Ryan Hines, Faison Teal, Tommy Connery somewhere behind them, but closer in proximity to the defendant. Ty Wood there is also there. And you heard Tyler Rich say, I was yelling at these kids, get the hell off my property. I looked out of the corner of my eye and I saw Raul cock his arm like he was going to punch Ty Wood. And that's when I just hauled off and cracked him in the face. And it was on. So I would submit to you, if the defendant walked on the property, confronted those kids, and started to throw a punch or pretend like he was going to throw a punch, he was the initial aggressor in the altercation by coming back, by approaching those kids, and by cocking his arm. He was the initial aggressor. He provoked the fight and started the fight. He gets hit. It's on. All right, now I can claim self-defense. Now I can take this knife out that I have in my pocket while I'm on the ground, open it up, right? All intentional conduct, and start stabbing kids, right? You heard him testify, I was flailing my arms. I would submit to you, if you look at any of the injuries on these kids from 3 years ago, those are deliberate stab wounds. Those are not flailing slash marks. Stab wounds. So he stabs Ryan Hines 3 times. He stabs Faison Teal in the arm. Again, upper, right? Left arm here. Hines up in the chest as he's working his way down. And Tommy Connery, you heard testimony from Tommy Connery, who comes over and he's trying to push him away. And he's on the ground. The defendant's on the ground, and he comes right after him and starts stabbing him in the leg 4 times. Deliberate. Again, what was his intent?
I don't think that case will be till next year. They just had a bond hearing. They just had a hearing where the family, who I think they raised like over $1 million, they declared destitute.
So what I have heard is that it goes by Carmelo's, his actual earning, not his parents'. So he is in fact indigent, but I don't like that loophole. I mean, again, he raised a lot of money.
Yeah, I think $3.4 million or something like that.
I thought it was $500K, and now they're asking for 1.3, I think, for more lawyering.
I might. I figured in for future inflation. If someone is watching 10 years down the line, that's what I did. So that's going to be an interesting case as well, because that story doesn't quite add up either. So it's going to be interesting to follow. And it's going to be a case that will be very, very. That'll be uranium to cover.
Yeah, I am not sure I want to cover it with a 10-foot pole. I'm like, yeah, no.
I have had one white on black crime where I still get called a racist, even though I said, I don't think she should have shot him. But apparently I'm still a racist for covering it. Yeah, well, I'm racist for using a southern accent too, so.
This wasn't self-defense. He went into that.
Oh, I thought you said stop.
Oh, no, but I didn't like the line where he said that he thought, oh, now I can use self-defense. Again, he's a 16-year-old. He's not thinking about anything. He's being a Billy badass. He wrote a check that his mouth couldn't or his mouth, wrote a check that he couldn't cover. And then unfortunately other people engaged. This is a sad and tragic thing of, young, stupid boys being drunk, wanting to be tough men and not realizing that tough men walk away. Tough men don't start a fight. Tough men, don't do this petty high school BS.
No, tough men end fights. Normal order. State defense state. The case we're talking about is the one with the track meet, where one kid stabulated another kid. I can't remember where it is.
I believe it's somewhere in Texas.
Yeah, it's Texas somewhere, but I can't remember where it is. But it's not coming up right now. They just had a hearing, and again, it'll be one of those cases that no matter if you cover it totally neutral, you will also be called every name in the book.
Yeah.
Most likely from both sides.
Already armed. His response to this fight was unreasonable when you look at it in totality. It was a fist fight that escalated by his doing because he was the only one there with a weapon. At some point in time, the defendant goes back to the car that's waiting for him. He would have you believe he was chased. I would suggest to you that the video shows a different story. But nevertheless, he's back at the car, looks back, and wants to run back in. He purposefully runs back in with the knife. And you hear Charlie Connery yelling, "He's got a knife, he's got a knife, he's got a knife." And there's another person there yelling, "Get out of here, bro." Because again, the Shelton kids didn't want them there. There was a communication to leave. Again, all of these things could have been prevented. This is Jimmy McGrath just before he gets stabbed at the end of the fight. He's not engaging the defendant, but he would have you believe that he or somebody else was so that he can cloak himself with self-defense or defense of third parties.
This is the guy that he claims he had to defend. As you can see, there's no one near him. The defendant is in front of this guy. This is the guy who's not here anymore. He gets one stab right in the bottom of his heart and bleeds out almost instantly. I don't believe he went in with the intent to kill. He went in with the intent to harm. And sometimes you're just lucky.
Yeah, I mean, this is unfortunately a sad, dumb teenage over testosterone thing. Again, no teenager thinks they're going to be the one to unalive someone. No drunk driver thinks they're going to be the one to, run over a bus full of nuns. But it happens.
Yeah. But with him in the street, the first 3 stabulations happened before he goes out to the car. Then he goes back in, passes his body being pushed out, said, "Go away now." And he then claimed he was afraid that they couldn't get away. And the defense, or the state pointed out, but there's plenty of space to get away. It's not a stand your ground state. So I think that will bury him. And that's why I still believe it's manslaughter. Maybe he should have been charged as a juvenile. And I think murder is too much.
Yeah,
He had the
he's
duty to-
making it sound like he intentionally went out like, oh, okay, well, he's really close. Like he had watched and gotten hard with Bronca and was like, I know all the things I need for imminent, danger. They don't think. Teenagers don't think, and they don't know the consequences. And that's why they do really stupid stuff.
Yeah. I haven't watched any of this trial. On that video alone, it's murder by manslaughter, I think, is what Livid Pigeon is saying. Yeah, I think it's manslaughter.
Retreat and not even go after Jimmy McGrath. He was unarmed and he did nothing wrong. And even if you believe from the evidence that Jimmy was involved somewhere in the fight somewhere, which there's been no evidence of that. But even if that's what you can infer from the video, I would submit to you that self-defense is not retaliatory. It's defensive. You can't come back and stab somebody just because you're mad. And that's exactly what happened here. He came back from the car. He ran back at people who were already, the fight was already done. Tyler De Silva clearly in the road. The fight was over. Kids were screaming back and forth. Tyler De Silva even said the fight was over at that point. You hear, "Get out of here, bro." And at the very end of the video, you see Jimmy McGrath step back.
Expert, I know it's 24 hours ago, but you covered the co-worker plea deal yesterday.
You were there. We all saw it.
Yeah, we saw you sitting there with your wine, screaming, "True crime, box wine."
Back like this to try to avoid the fight, the stab wound, the deliberate stab wound in his chest. He didn't.
Congratulations, Kim, with your birthday. 21, you never looked this young. No, it's just the beginning is them discussing the jury instructions, and then it's boilerplate prosecution, closing.
Stab him in the foot. He didn't stab him in the lower leg. He stabbed him right in the chest. What was his intent when he did that? When that happens, you hear Jimmy McGrath yell, "I've been stabbed," and he collapses. He collapses.
Yes, sir. That's him at the car. There's still a fight going on. Now he's pushed out into the street. And that's when he stabs him.
Okay, well, now seeing that
So he
video,
unnecessarily stabs Jimmy.
I mean, yes, his friend was pushed away, but that doesn't stop. I can see where he's trying to go with defense of others. He got pushed out, but they're outnumbered. Their car has just been mobbed. He's been sprayed in the face. And again, stupid, dumb teenager, didn't think he was going to hit anything vital.
But the problem is he re-engages in a non-stand your ground fight. Yeah, because his body was pushed away and could just have run to the car, jumped in the car, raced off.
Yeah.
Then they could potentially have killed someone if they tried to mob the car again, but then it would be even clearer self-defense.
It just, as a prosecutor, I wouldn't do this route where it makes him sound like an evil mastermind, because anyone who has teenage kids is gonna realize, no, the hell he wasn't, planning with forethought. So I get where he's going because he's trying to get the murder charge, but it just doesn't ring true if you have.
No,
Also,
I feel
was
he's
snowing?
overcharged. He's overcharged. No, it's just because of it's night and there's everything in the air.
Okay.
But he's
I was
overcharged.
like, I can't do more snow. I can't.
This was in May, I believe. So.
Oh, good. Thank Jesus. I mean,
Right.
not for the
You're going to hear an
everything
instruction
bad,
about intent, right? And I'm sure the defense attorney's going to get up here and argue, he didn't wake up that morning, want to kill anybody or stab anybody. It's not what intent's about. Intent can be formed in an instant. It can be formed within a moment. I would submit to you at the beginning of that fight that was not on video, as soon as he got hit, he informed the intent, the specific intent to stab people and cause serious physical injury, right? He went back to the car and he informed the same intent when he turned around and saw Jimmy. I'm going to stab this kid and get out of here. Why else would you stab him in the heart? You stab him right in the chest, piercing his heart. After he gets back to the car, he tells you that, or Snyder indicates, gets back in the car and he says, I just stabbed like 4 kids. So he knew how many kids he stabbed. He knew how many kids he stabbed, but he knew he stabbed kids. He got to understand here. I don't know if I stabbed anybody, right? We heard that testimony. I don't know if I stabbed. I was the only one with the knife, but couldn't even say it. But he said it that night. He knew he stabbed kids that night. So we know he did it. They go back down the road. No, before we get there, they take off. De Silva jumps in the car. They take off. They take a left. They go down Adams Drive. They're at the cul-de-sac. He says, stop the car, and throws the knife into the woods. Why? Consciousness of guilt. You'll hear an instruction about consciousness of guilt. Why are we getting rid of the weapon, right? Gets back in the car, go, go, go. They go back down to 36 Laurel Glen. Mackenzie's sister's there. He tells Jack and Tyler, I'm going home with Mackenzie. Jumps in the car with Mackenzie, and the cars leave the area. Mackenzie drops off Keenan and Dimitri, and then they subsequently drop off the defendant at his house. Mackenzie was mad, right? She told you, I was pissed. I didn't want to be there. I was mad at him. They were going there to fight. I didn't want to be there. I didn't want to be involved in any of that. You know? They were all going there to fight that night. But after the defendant gets dropped off, you hear about the text messages that go back and forth between Mackenzie, who was his then girlfriend, and Raul. And he's saying things like, I can't text anything. I wasn't there. You know I wasn't there. Nothing is happening. Don't text me. I'm going to Florida. I didn't do anything.
Those texts are really
They
bad.
want to put anything in writing. You also hear that he spoke to Tyler De Silva on the phone. And when he spoke to Tyler De Silva on the phone, he says, dude, I fucked up. I'm sorry. I don't know what to do. Because he knew what he was doing that night, and now he's having buyer's remorse. So again, what was his
Buyer's
intent?
remorse?
Right? You guys are really going to be able to examine what his intent was.
That's when you buy something and you regret it.
No, I know,
This
but
is
this
what
is
we
not
men
the-
call wedding nights.
No, but you could say remorse, but buyer's remorse, I don't think works in this situation. I do like that he talks with his hand because you guys usually can't see me, but I do talk with my hands a lot. I don't like his delivery, and I haven't even watched the trial.
He was really good on the cross-examination of the defendant, but I think when the female attorney or female prosecutor has been asking, she's way better. But no, he seems a little smarmy to me. I don't like him either.
And the judge is going to give you an instruction such as there's no particular length of time necessary for the defendant to have formed the intent. Intent can be formed in an instant. It can be created in a moment. Intent may be, and usually is, inferred from the circumstances of the crime, since no witness can come into court and testify that they looked into a defendant's mind and saw what his intention was. You can look at the number of wounds inflicted, the location of those wounds on each person's body, the type of instrument used to cause those wounds, and his conduct during all of this. I would submit you could even look at the conduct from Lazybrook. What was his conduct during that fight, and for what his intent was later on that night. In this case, the state contends that there were 9 stab wounds inflicted by this defendant on 4 different individuals. They were stab wounds, not slashes. I would suggest to you that a person who stabs multiple people multiple times in areas of the body that would cause serious physical injury and death intended to cause those serious physical injuries and death. There's no other rational conclusion. So that's what this case is about. The defendant was enraged about what had happened earlier. He armed himself and he returned to a house to face those kids with the intent to stab somebody. He could have waited down the street. He could have called the cops. He didn't have to go back. He did. He intentionally went back. It doesn't make sense when someone says, I was very scared, frightened, and panicked, to go put yourself back in that situation. It makes 0 sense. And because of his conduct, 3 people are going to have to live with scars for the rest of their lives. Both men.
He came home, he didn't escape. Well, he did escape to Florida for 1 day, came home, didn't turn himself in when he was told that they had an arrest warrant for him, and then turned up at the police station at 4 in the morning. So, again, he didn't, as they tried to say, yeah, I turned myself in. I wanted to talk to the police. No, he slept Tuesday, the entire day, allegedly. He slept from he came home 10 o'clock Monday evening till 4 a.m. Wednesday morning when he went to the police. So, and that's with less than 24 hours on a Florida trip. A Florida trip he wasn't supposed to take. Just, again, he didn't go to the police station the next day and say, I think I did something bad yesterday. I might have stabulated someone in a fight yesterday. It was pure self-defense. I was just protecting myself and my body. No, he did take an unexpected trip to Miami. I think it was Miami. No, it wasn't Miami. Somewhere in Florida, which he then returned from the same day almost, and then slept an entire day where people tried to reach him, and he was aware of it because you just heard the text messages that he got from his girlfriend. So, to me, that's kind of sus. Because if he's just had done it as self-defense, he could just call the police and said, "We got jumped. I had to defend myself."
Well,
You don't go running to Florida.
That's the difference between the Rittenhouse case. I mean, he tried to turn himself in to the police officer, I believe, at the end of the street, and they kept telling him, go home, we don't have time. Then he went in, I believe the same night or very early morning, to turn himself in. For a self-defense claim, you have to be believable, you have to be reliable. But part of this, I think, is the jury going to give him sort of more grace because he was young? You're 16 years old. You're pretty sure you just committed how many felonies? How do you act? I don't know.
Rittenhouse was innocent, proven in court. In a self-defense case, if there's no other witnesses to tell your side of the story, it's pretty normal to take the stand. His friends got plea deals. Yeah, but again, if he had gone to the police, if when he came home that night, where his mom and brother was packing, and he said, "Mom, something really bad happened," because she was screaming when she saw his face, and he just said nothing happened and went to bed. If he had said, "We got jumped by some guys, and I pulled a knife. I don't know if I hit anyone. Can you call the police and hear what the hell's going on? I might have struck someone, and I'm deadly afraid. But I just want to figure out if anything happened." But he didn't. He said nothing happened, and he went to bed. And then he flew to Florida the next day. It could be a stupid 16-year-old. Could also be, I know I fucked up, and I'm getting out of town.
And it'll be interesting to see whose narrative they go with, because juries are wild animals that can't be predicted.
James Bond, this is the same, sorry I'm going to say it, stupid argument that the anti-can read people are using. Read the first line of jury instructions. Innocent until proven guilty. So if they are not proven guilty, they are innocent. It doesn't just because you don't like what he did. I think taking child molesters off the street, probably not the worst thing I've ever heard about. But if you're not found guilty, you are, in fact, innocent, because every jury is instructed. You have to go on beyond reasonable doubt, and you have to see every suspect as innocent until proven guilty. When they're found not guilty, they are not proven guilty, which means, say it with me, class, innocente.
Innocente.
That's Italian for innocent that I just
Baker, would you like to hear my new campaign slogan? Plant more trees, more trees, less a-holes. So my proposal, and I think Greta, how dare you, will be great with it. We plant an a-hole, fertilize a tree.
Yeah.
Mentally and physically. And James McGrath lost his life unnecessarily. And the ripple effects that's caused his family. The credible evidence in this case shows that on that day, he intentionally caused...
Please don't call people asshat. Keep the tone light. We don't need fights in the chat again today, but the rest I agree with.
Physical injury to Faison Teal. He caused that injury by stabbing him in the upper arm.
No, you can't be proven innocent because you are presumed innocent until proven guilty. So you are innocent if you're not found guilty. It's really easy. And you can't be legally innocent and factual responsible for a crime. If you're legally innocent, you're not responsible for the crime. And I know, well, OJ, he was all the guilty in the world. But that's the beauty of the American justice system. 12 people can say, fuck the law, we're getting out of here. And that's what they did in the OJ case. If I did it, but still, legally, that man was innocent. Well, he was proven guilty in a civil court. Doesn't have the same weight because there's a lower bar for conviction in a civil case. But back to this one.
With a dangerous instrument. With regards to Tommy Connery, the credible evidence shows that he intentionally caused serious physical injury to Tommy Connery. He specifically intended to cause that injury by stabbing him 4 times in the upper leg, causing deep stab wounds. You heard testimony from his doctor. She was concerned about compartment syndrome and him losing his leg. Deep stab wounds. I mean, deep stab wounds. These are not flailing slash marks. These are deep stab wounds. Again, the manner in which the wounds are inflicted. It's not corroborative of slash marks. And he did that with a dangerous instrument. With regards to Ryan Hines, he intentionally caused serious physical injury to Ryan Hines. He had the specific intent to cause that injury by stabbing him 3 times in the upper torso, causing a collapsed lung and other injuries to his lower abdomen and hip area. And he did that again with the dangerous instrument. And with regards to Jimmy McGrath, he formed the specific intent to kill Jimmy McGrath at the moment he came back from that car, turned to him, and plunged the knife into his heart. He didn't slash at Jimmy McGrath. He plunged the knife into his heart, through his rib cage, and through his heart, and the poor kid bled to death right there on the front lawn. You know, the judge is going to give you an instruction on sympathy. You need to follow that instruction. And I apologize for getting a little choked up here because I have a son as well. And I can't imagine what it feels like.
And the Oscar goes to,
And I hope
you
no one
like
else
me, you
has to-
really like me.
I hope no one else has to go through this ever. It's terrible. I apologize for
He's verklempt.
taking a moment. But again, the judge is going to give you an instruction on sympathy, so please follow that instruction on sympathy. But we are confident that after you review all of this evidence,
We saw the
know,
Brian
when-
Koberger. He had a little in his voice. This one,
Well, okay, Baker, when you look down and you have to rub at your eye to try to get a tear to come out, next time just use Vicks Vapo Rub. It'll water your eyes. And
that was
here, look, I have a daughter that's getting ready to go to college. That's why I didn't, want to cover the Koberger case. But I didn't go, you guys, I have a child who's going to college, and that's why I'm not covering it. I just didn't cover it.
no. And again, the Koberger guy said he just his voice cracked and then he moved on. He has been looking at the pictures of 4 brutally slain. This is gonna sound harsh. Don't take it the wrong way. These are pretty clean cuts. There's a lot of blood coming out of it, but it's not someone who has been slashed up potentially we don't know anything from the Koberger trial, but I could imagine if he is the deviant that we now kind of think he might have been, I can see faces being slashed. That's a normal thing when you have like a sexual motive because it's an unobtainable prize that you can't have. That's why some of these guys unalive young pretty women, and they will mess them up. That's a different thing.
The Koberger, he did have that. Santa Claus had, that little wobble, but then he went on and he tried to be. He didn't say, "Excuse me, I'm the Glems."
Yeah.
This is not professional. I shouldn't know that the prosecutor has a child. That's not what this case is about. This is about.
This is
about. This is heartstrings. This is. Put your own kid into this.
Yeah, it's very prejudicial, and they should object, but they can't because he just said he had a kid.
You will find the state has proved each and every element of the charge beyond a reasonable doubt. You'll find that the defendant intentionally caused the death of Jimmy McGrath, intentionally caused assault in the first degree to both Ryan Hines and Tom Connery, and intentionally caused physical injury to Faison Tail with a dangerous instrument. We're confident after you review all the evidence, you'll determine this was not self-defense. He provoked this fight. He was the initial aggressor, and he had a duty to retreat, and he should have. The state urges you at this time, well, after you deliberate the evidence, we urge you that you find the defendant guilty of all the crimes charged in the information. The defense will now have an opportunity to speak with you. And when he's finished, I'll come back and speak with you again. Thank you.
I didn't think I'd find a prosecutor that I found. Go ahead, Baker.
Yeah, I'm just saying this was just boilerplate. He did what he should, and he hit the highlights, but really didn't like the oh my poor kid.
Yeah, I didn't think I would find a prosecutor that I found more smarmy and slimy than Hank, but that little cry fest, it felt inauthentic. And again, I don't care. This is not about your family. Keep it about this case.
Yeah, and this, if I would, as everyone says, I would be highly upset by, again, you have the power, you have the money, you hold this kid's life, and you get emotional. If you're so emotional that you're crying in your closing, you take yourself off the case. I know police officers, I know laymen. That's why I sadly have had a few kid cases, because I am the one that'll do anything because I'm Mr. Teflon Soul. So they call me because other laymen said, I just can't do it. And after I've had Baby Baker, yeah, I will also have to rethink my approach to cases. But if you can't do it, you can't do it, and that's fair. But you don't stand in closing and cry and say, I have a son too. You are power. You are the state. You are a rock. If you can't be a rock, get a new job.
And we shouldn't be, I hate to pull an uncivil here, but the law is the law. They need to prove all the points. Not one single emotion should come into this. You are simply looking, did the state meet its burden? In fact, the irony of him talking about sympathy when he is trying to garner sympathy. Where the hell is Alanis Morissette?
Yeah. Let's sing a song that's absolutely not ironic and call it.
It's unfortunate, not ironic.
Yeah. Let's hear what the ponytail has to say. This is going to be great.
Pony.
Y'all are probably tired of seeing me come up here and set up with all my stuff, so I'll just get right into it. This might be a hard case because it involves young people. It might be difficult because it involves young people, right?
He looks kind of like.
But it is not a complicated case. It is a case about the most basic right that any of us have, which is the right to defend ourselves when we're faced with people that are intent on doing us serious physical harm. It could be as much as death, serious disfigurement, and all the other things you're going to hear about in that instruction. You've heard from the state here telling you, I guess, that Lido Valley is a criminal mastermind who came over there with the plan to be able to use all of this so that now I can claim self-defense. You heard Mr. Valley get on the stand. Mr. Valley, a criminal mastermind, can put together a plan like that? And back home, we'd say, son, bless your heart, but that was mighty stupid. There was a whole lot of stupid to go around that night. There was a fire that got lit earlier in the night, and it started with all that drinking that was going on.
Yeah, I was hitting the wrong screen.
Oh.
Sorry.
So that's okay. I would like to speak to all the semi-Southern and Appalachian people, but back home you would have put a little bit of twang on that, like, son, that was mighty stupid. You don't say, son, that was mighty stupid. If you're going to use a colloquialism that's generally like an Appalachia Southern, put a little Southern in it.
Yep, this reminds me a little bit about, hey, I'm so glad you kind big city folks took so well care of me and my team when we done come down here help Miss Sarah Boone out. He turned real hick.
Yes.
But this is why I don't like this guy.
And nobody there to say, what are we doing? How do we come into all of this? That's the first fire that was lit. There were a lot more along the way.
He has a skull ring. He has the middle-aged. What am I doing with
The
my
little
life
beads.
Yeah, and he has the ponytail and he has the motherfucker beard. This guy rides 125 cc Kawasaki when he goes out with his
This
buddy.
man had 15 Livestrong yellow bracelets and all the other, like the bracelets for a cause. His arm was all the causes.
But good call, LV. He's still in his emo phase.
But again, not a complicated case. Mr. Valley took the stand. He talked to you. He didn't have to do that. Mr. Valley used a 3-inch pocket knife that Jack Snyder gave him, that Jack Snyder brought, that Mr. Valley didn't even know existed prior to that night. Mr. Valley didn't even know existed prior to Mr. Snyder giving it to him. Where was Lido Valley seated when Jack Snyder pulled that knife out and had it on his lap? Was he in the front passenger seat? No. That was Tyler De Silva. Lido Valley's behind him with Mackenzie Trafficante on his lap. There's no way he can see that knife in Jack Snyder's lap. And Jack Snyder's the one who told you he took that out and put it in his own lap because he was so scared about what was going on. So Lido Valley can't see that knife, doesn't know it exists. Mr. Snyder told you there was no way that Mr. Valley could have known it was there before. He'd never brought it out. He'd never said to him, hey, I got this knife. Let's go riding over to 43 LGD and get a little payback. None of that happened. So it doesn't make any sense when Jack Snyder tells you that Lido Valley asked him for a knife that he didn't even know existed. Now I get it. Maybe some of you want to believe Jack Snyder and Tyler De Silva. Maybe you say to yourself, gosh, those kids, nice looking kids, they get up here on the stand. Why shouldn't I believe them? Well, ask yourself, why should you believe them over Mr. Valley? Is there something about Mr. Valley and the way he came up here and took the stand and testified that tells you you should disbelieve him, but believe those two?
They had 2 immunity deals. I'll believe him more. And thank you, Casey Gypsy Muse, for becoming a member.
Yeah, I mean, you do have to point out that there are, benefits for these two being witnesses and what they promised the state they would say, or definitely you have to point that out to the jury, and they're the ones that are going to decide whether they were truthful or not.
Yeah.
I didn't hear the state talk at all about exhibits 94 and 96 when they were up here. Did you?
Mage.
What are exhibits 94 and 96? I bet you remember.
I think he
hope it weighed heavily
he really
on your
wanted
mind.
to tank, but everyone
Imagine if
just-
I came up
Can you
here
play mage?
and asked you to believe witnesses.
But he's the mage who
I can't even
who
call
rolls
them
false
paid
on everything.
witnesses. They have something more valuable than any money they could ever be given. What is more valuable than a complete immunity agreement? Anything? Is there anything that a 18, 19, 20-year-old kid would not come up here and do or say in order to avoid any penalty whatsoever for their actions? Does that bother you? Does that disturb you? It should. Does that sound like justice for all? Does that sound like justice for some? Does that sound like equal justice to you? Going to give those 2 kids immunity agreements. Jack Snyder drove the car over there, gives the knife over to my client. Tyler De Silva gets in that same car, rides over there to 43 Laurel Glen Drive, says he's going to go make peace. Listen, there was a lot of stupid going around that night. Tyler De Silva got up here on the stand and told you, well, I thought I could go up and talk to them because I didn't have a problem with them. Maybe he did. Maybe some of you sitting here look at these kids and think of your own kids. State's attorney did. I know I did. Would any of you put your faith in something as important as this in a 16 or 17-year-old? Would you have reason to doubt that maybe they would fail to go to the grocery store and get everything that you had for them on a list? But we're going to sit here and expect these folks to give us the evidence that we need in order to convict somebody of murder who's charged with the same things that these folks could and should be charged with. They told you that. They know what they're exposed to. I went over it with them. I asked them about it. They know exactly what they're doing when they're coming in here. Jack Snyder's story doesn't make any sense. He gave him the knife because he asked for the knife that he didn't know existed. It's not just implausible. It's not just improbable. It is impossible. You don't ask for something that you don't know exists. He didn't know it existed before that moment.
No, he's arguing for lesser included because this takes away the premeditation aspect of it. Even though premeditation can arise in a second, the state argued that he went there to stabulate, but he didn't even know there was a stabulator present.
So we watched
we
the
have
ring
all
video.
said that. It's
The ring
unfair.
video is the 36 Laurel Glen Drive. That's exhibit 44. You'll have that available to you. You see the car stop. You see Mackenzie get out. She's walking up ahead. Raul's already on the curb, a little ashamed, in a bad situation here. Mackenzie's obviously upset with him. She's walking down towards the curb. Tyler De Silva gets out of the front. And then the car stops. And it's there for some time before it drives off. Mr. Valle told you that's when Jack Snyder threw him the knife and said, just in case. Just in case what? Just in case this situation that I caused over here at 43 Laurel Glen Drive comes running down the street at you, throwing things and hollering things, and I'm about to drive off and leave you? Does that make more sense than, he was pissed off. He was the most pissed off. He was angrier than anybody else there. And he asked me for that knife that he didn't know existed. Jack Snyder has every incentive in the world to make these folks and you promises that he just can't deliver on. He's got no more powerful, there is no more powerful incentive in the whole world than what he's got. What are the terms of that agreement that he was given? He's got to come in here and testify truthfully. But who makes that determination? Who's he working for when he's under that immunity agreement? Not me. Not you. The state. And what did they all tell you almost without fail about what they did before they came in here? They met with the state's attorney a number of times. To do what? To get ready to make sure that when they took that stand, they were going to testify truthfully. And I put air quotes around that because what does truthfully mean in this instance? To those guys, as they told you, it meant not deviating from the things that they had said, the things that they waited 7 months and after they'd gotten an immunity agreement before they were going to say anything. Now, when we were in here during jury selection, some of you said, well, there can be a lot of gray. There's more than two sides to every story. That was a bit of truth. How many sides to a story did we get here? And some of you said, well, a lot of people will lie.
I didn't take a gummy this morning,
You
but I
said
feel
that
as though
maybe
I
you had a
have.
little bit of an idea about what had happened here.
I'm
You've got way more of an idea now about what happened here.
Huh?
And some of you said, well, I don't expect everyone to testify truthfully. People may want to defend or protect their families. You need more than just common sense to determine credibility. Some of you said you had an experience with a kangaroo court. You know what that's like. Don't turn this into a kangaroo court by putting any more weight into the testimony of Tyler Da Silva and Jack Snyder than what it deserves. And it doesn't deserve any more weight than the paper and the ink on which it is written, because that incentive is overwhelming. That's more than just defending your friends or your family. That's defending yourself. And some of you said, if we don't follow the law, our system wouldn't work. It's not here just for one person. It's not here just for a few people. It's here for all of us. And that's right. You all take seats that were laid out for you hundreds of years ago. You come in and you take those seats. And you got to put your sympathy aside. Sympathy for the victim, sympathy for the complainant, sympathy for anybody. It's got no place here. Some of you have experience taking things through a process, doing quality control and making sure that everything has been met along the way. Use that experience here. Does this make sense? Would this pass through quality control? I told you before, some of these witnesses, if not all of them, are promising more than they can deliver. Imagine If somebody tells you something that you know just can't be true, somebody tells you they got to make a delivery and it's going to take them an hour and a half to get from here in the middle of the day through the city down to DC in 3.5 hours. They're making you a promise because they want you to believe them. They know you'd be really happy if they could actually make that trip, but they can't deliver on that. That's more than what they could possibly do. That's what these witnesses are doing for you. They're telling you things that they can see that couldn't have been seen. Why are they doing that? They want to avoid consequences that Mr. Valle is now saddled with. They want to protect themselves. They want to protect their friends. And they want to protect the memory of a loved one that they lost. Now, during jury selection, I asked you all if you could be open to the idea of self-defense. And to a person, you told me that you could. Some of you said you'd had to use some self-defense before. And you said you'd be open to it and you could understand that the law allows you to use self-defense. To defend yourself, to defend loved ones. Whether or not you had experience with doing that, you said you'd be open to it. I don't know what you thought you were going to hear or what you thought self-defense looked like. Some of you had experience with it, some of you don't. But this is what self-defense looks like. It's messy. It's chaotic. It transpires quickly, and you don't have to make the best decision. That's not what the law requires. That's not. It's a higher bar than anybody could be expected to make. It requires that you make a reasonable decision, that you make a decision that you had a reason for. You watch those videos, you know there's a reason for the defense that he used. He's down on the ground. He's getting kicked, stomped, punched, and he's being given no reason to believe that that's going to stop unless he makes it stop.
It sounds like the air condition is on the fridge, and the guy who sounds like he's sleeping doesn't help either. Its audio is always bad in this case.
Nobody's saying, that's enough, guys. Everybody up. Just a few licks, and then we'll let them go. That didn't happen. What did happen? People joined in the fray. There were at least 15 to 20 people out there, at a minimum. And you know that because if you watch that video, you can count them. Michael Samperi, Sal Perry, Jacob Villalobos, Matthew Lockovich, Ryan Hines, Ty Wood, Tanner Chernowski, Tommy Connery, Charlie Connery. The list goes on. We heard about all of them. We see some of them. Alex Burnson. Some of them couldn't be identified. Those are at least the people that we can see. And Mr. Valle's down on the ground, getting kicked, punched, can't tell what's going on around him. Ryan Hines is on top of it. And Ryan Hines is punching him in the face. And Ryan Hines tells you, I didn't think he was aiming for me necessarily. Because he wasn't. He reaches in his pocket and he takes out the only thing that he's got there. The only thing at that point that he thinks is going to make them stop, because they've not given him any reason to believe that they're going to do so on their own. And maybe you're thinking to yourself, well, yeah, but he said he brought a knife to a fist fight. No, he didn't bring that knife to that fist fight. He had that knife in his pocket because Jack Snyder took it out and threw it to him. And he's got some kids running down the way. He picks it up, sticks it in his pocket. Now you heard the state argue to you, well, you know, they submit that that's when he gave it to him now, is when we see it on that ring video. Agreeing, I guess, with what Mr. Valle tells us, which is in fact, as you will recall, entirely different than what Mr. Snyder says, than what Keenan Frasick says. Snyder tells you he doesn't give him the knife until it's asked for, which again is completely ridiculous and unbelievable. But he tells you that happens after they're looking at the car. After he's dropped them off, driven down the street, leaving them there, comes back, and then everybody else who was still in the car gets out. Do you remember that? That was Jack Snyder's testimony. He didn't tell you that he threw it to him while they were right there. And Keenan Frasick, what does he describe? A mad scramble through the console, through the glove compartment. Where's that knife? Give me the fucking knife. Didn't happen. It's just unbelievable. It's not what Jack Snyder or anybody else describes. But Jack Snyder and Tyler DeSilva and all these other kids that are in that car, all these kids that had once been his friends, all these kids who haven't talked to him ever since that night, though they still remain very close with one another. Those kids all told you that Mr. Valle was the most upset of anyone there. More upset than Jack Snyder about his car. More upset than Tyler DeSilva, who was worried about the damages and how much it was going to cost. He was the most upset of anybody there. And he went into a rage. He was so angry. Gosh, never seen anybody that angry in my life. He goes digging through the car and this and that and the other. Why? Does that make any sense? Of course not. Not unless you start to think about what's motivating them to ostracize and distance themselves from Mr. Valle, to aggrandize what he was doing so they can demonize it, so they can wipe their hands at Mr. Valle. I had no idea. I don't know. He was so mad. He was so angry. I just thought we were just going to go get back in the car and I was going to go make peace. It doesn't make any sense. Mr. Valle told you he and Tyler DeSilva were best friends. Again, it might have been mighty stupid to get back in that car. But there was so much stupid running around that night. And now Mr. Valle's the only one sitting here facing anything for it. Because he got in that car and had a pocket knife in his pocket. You'll recall not a single witness telling you that he got out of that car and came onto that lawn with that knife displayed. None of them saw it. He didn't get out dancing around with it, licking the blade, asking who wants a piece of this. None of that.
Licking the blade?
He's not a person who carries a knife. It wasn't his knife. And mind you, one of the charges that you don't hear here is criminal trespassing. It was stupid to go on that lawn. I would agree with you. We could argue about that, and I would concede that. But it wasn't criminal under those circumstances. Those kids, for whatever their reasons were, had invited them there and wanted them on that lawn. What do they tell you? Did we hear a series of witnesses come in here and tell us all the things that they could remember so clearly, and they all could remember. I looked in the car. I might have been a long way away, but I could see Mr. Valle, and I could see Tyler DeSilva, and I could see Mackenzie Trafficante, and I could see Jack Snyder. But then when it came time to tell us, well, who else was there with you? Who else went out into the front yard with you? I can't really recall. Really? But you told us that all those folks were your friends, lifelong friends, grew up with them from childhood, been over to their homes, so comfortable that when they got to the house, they could walk right up and go in through the Bilko doors. That they could go downstairs, nobody would even blink an eye, right? And when they got down there, they could see their friends, they knew who was there. But then when they all went outside, do you remember this? It was everyone got up. All of us went together. Oh, really? Who were you beside? Ooh, I can't recall that, actually, now that you mention it. Oh, okay. Well, who was at the car? Some of them told you. You know, there was a couple of us at the car, right? Maybe 3 or 4 of us at the car. Then others told you, no, there was maybe 10 of us that went to the car. And there were others that told you, no, there was more like 15 or 20 of us, and we were all around the car. Some of them told you, I didn't see anybody touch the car. I didn't see anything going on over there. It was peaceful, what I saw. And yet others told you, no, we had our hands on the car. We were rocking it. There was somebody bouncing up and down on the rear bumper. Who? I can't recall. Oh, okay, but you just went through a whole list of folks that you could tell us were there, that you saw downstairs, and you all went out together. So surely you must have seen Tyler Rich by the car. I don't recall. Oh, okay. What about Ty Wood? Where was he? I don't recall. You will have the opportunity to see all the evidence here as long as you want, as many times as you wish. Do a test, do an experiment. Go through those witnesses. See when they can't remember things and ask yourselves if that's convenient, if it seems like they're protecting their friends. Or ask yourselves, is there something wrong with their memories? Why is it so selective? Why can they remember some things but not others? And do those things seem designed to protect their friends and themselves? Right? Tyler Rich has got to tell you that he told Tyler DeSilva to get the fuck out of here when he sees him on his lawn. Because what he can't come in here and tell you is he didn't tell him get the fuck out of here. He wanted him on that lawn. And he wanted for his friends and him to be able to jump them and get some payback. Because if he tells you that, and if he tells the cops that, then he and his friends could get charged. Maybe they get an immunity agreement. Who knows? But they certainly have to admit to some conduct that is criminal. And they're not gonna do that. They didn't do it that night. To the extent that they came in here and told you things that were different from what they told the cops before. I tried to point that out. I asked every single one of you during jury selection, probably looking at me like, what in the world is this all about? I gave you the parking lot example. Everybody remember the parking lot example?
No.
Right? I said, what would you be interested in knowing? Right? If you came out and you saw 2 strangers that you'd never met before.
Who, if any, remembers the parking lot?
That must have been in voir dire or voir dire or voir dire in the Midwest.
Yeah, maybe because yeah.
Baker, we've both been up very long,
Yes.
both of our 4 a.m.s respectively. What in the weaponized ADHD is this man talking about?
That you can't trust the other people because they had a plea deal.
Yes.
He's just using a lot of words to say that.
Sir, if you have tiny hands like me, don't wear a big GD ring. It just makes your hands look smaller. Now, I'm a woman and having small hands is okay, but just a tip.
Yeah. I've heard ladies say that before.
We
Just a
try.
tip. No, it's more just a tip.
Well, you know how we feel about postmarital sex. We're against it.
Yeah. It is Latin, Mo, an unspoken language, so say it any way you want. There's no known correct way. No, but people will say it's called wadir or wadire or watery. It's the same with after David.
Yes.
And they're each pointing at each other and saying, he
Hey,
did it.
AA.
And you look at your white car. Remember the white car? It's got a long red gash. Remember the red gash? I said, would you be interested in knowing whether either of them drove a red car? You guys look at me, you're kind of like, I guess. I said, okay. Would you be interested in knowing whether or not there was any objective, other evidence that you could look at, like surveillance camera footage? He said, yes, that would be interesting
I think that'll always be on the. I don't think it's. I'll goggle if it's mandatory.
to me. And I said, okay. Would you be interested in whether or not there were any eyewitnesses or people who claimed to be eyewitnesses? And you all said, yes, I think I would be interested in that. And I said, would you be further interested in knowing where those people were standing and whether or not it was possible for them to have seen what they claimed to have seen? And you all said, yes. And then I finalized that and I said, would you be interested in seeing how all of that evidence either aligns or doesn't? And you all said yes. I know you did, because I wouldn't have chosen you otherwise. That's your job, is to look at that evidence. It's my job, based on what you told me, to try and show you those things about the evidence that gives you some doubt about what you're being told. You're being asked to align yourself with Tyler DeSantis.
In Connecticut, murder convictions carry mandatory minimum prison sentence. Specifically, a standard murder conviction results in a sentence of 25 to 60, with eligibility for parole if defendant was under 25 years old at the time of the offense. Murder with special circumstances, however, carries a mandatory life. This isn't with special circumstances. And if they go by the 65 rule, then if he gets the least, that would be 15 years in prison.
Silva and Jack Snyder. You're being asked to condone that testimony and accept that and say, I don't have a reasonable doubt about what those two fellas told me. Again, would you trust those two fellas knowing that that had that kind of incentive under any other circumstances where you had a decision as serious as this to make? If they were the two guys, the paid spokespeople, that were telling you about a surgery that you should get, would you want to know what sort of value they were being given to tell you that that was what you needed to do? Of course you would. Would you make a serious decision and not?
Autopsy pictures in this case will be absolutely nothing. It's one stab, just goes right in and right out. It's not gonna. The other kids would have looked worse, and they were shown in court. They would have looked worse. I think the autopsy photos were shown when the ME was on, but the other people will have looked way worse than the guy who died because he got one stab exactly the right place, and that's an instant killer.
Yeah, and depending on if he's stabbed in the pericardium or the actual outside sac of the heart, he would have bled out internally, not externally. So it's going to be a much cleaner look than, say, the slash wounds.
The guy who had his fat cut out of his arm, which is probably the least bad cut, will have looked the worst because yeah, your arm fat is hanging out. It's going to look like shit, and you're going to have blood everywhere. But the autopsy will have been almost nothing because it's a simple in and out. It's not going to be that bad. I don't think it'll sway people.
Have a reasonable doubt about it on the basis of those two folks? Would you trust that kind of evidence under those circumstances? Of course you wouldn't. Don't start doing it now. Why would you? You'll never forgive yourself if you do that. Don't overlook your reasonable doubts. This system is built on reasonable doubt. It's fundamental because none of us were there. We're looking at it after the fact. We're trying to determine, has the state proven its case beyond a reasonable doubt? You may feel inclined to try and solve the crime or somehow make things right. That's not your job. You can't fix all the ills that led up to that night. Your job is to determine whether or not you have a reasonable doubt about what happened that evening based on the evidence that you've been presented. And I think you've got more than a single reasonable doubt. You've got reasons to doubt Jack Snyder. You've got reasons to doubt Tyler DeSilva.
Jesus, he keeps going.
And you should heed those doubts. That's what the law tells you to do. Listen to your doubt. Give your doubt credence. It is, in fact, what binds us because it's there for all of us. And if you don't follow that doubt and give it the credence that it deserves, you're not following the law. And you're leaving these seats in a lower place than they were there when you took them. Just as fundamental to our system is the presumption of innocence. And again, I know I asked every single one of you whether or not you could uphold that. Whether or not you could tell me as you sat there, look at Mr. Valle, that you could presume him to be innocent, despite the fact that he had been charged with these things. And again,
This case is 4 teenagers who got stabbed. One of them passed away. The defendant claimed it was self-defense. Everyone else said, nah, he wanted to do it. 2 other people who have touched the knife that night took an immunity deal. Every witness had a different story. There's videos, but it's 18 seconds. You can't see anything in it. And right now it's closing arguments. The state tried to pull the, convict him because I have a kid at home. And this guy is... don't trust the state, I think is... he's been talking for an hour and I don't know where he's going.
you know, we made it kind of easy for you. This is not a case of a whodunit. This is not a case where we're claiming somebody else, who knows. No, this is not a case about who did what. With the exception, perhaps, I guess, of Faison Teal, as I think about it. There's no evidence really to show you that what happened to Faison, cut on his arm there, was as a result of a stab any more than Faison coming in and getting in a couple stomps, somebody pushing him from behind, and him getting a cut there. There really isn't. But it's not about who had the knife. It's about why and whether or not that was reasonable. Did he have a reason to do that? Or was he just out there to kill somebody? The state gets a lot of things wrong about this case. But it got one thing absolutely right. This is a specific intent case. But it's not specific intent to murder. You know that. You sat here through all of this. There was no specific intent to go out and murder. In order to believe that there was specific intent to murder Jimmy McGrath, you would have to believe that Mr. Valle was some sort of trained knife fighter who knew that by taking a 3-inch pocket knife and inserting it between the 6th and 7th intercostal, that he could strike directly into Mr. McGrath's heart. Now again, he's no criminal mastermind, and he's certainly no trained knife fighter. What he was a 16-year-old boy down on the ground getting stomped and kicked. and the numbers were overwhelming. Was it 15? Was it 20? Were they all focusing their attention on him at one point? Were they all focusing their attention on Tyler Da Silva? In that chaos, that's not a determination he could or had to make. None of us likes violence. We're not up here saying violence is okay. That's not part of the argument. But what we're saying and what the law says is that when you have a reason to believe that you need to defend yourself, that you have a right to do that and to use the force necessary. And that's what he did. And how do you know that that's what he did? Well, I guess if the state's now conceding that he got that knife during that exchange down on 36 Laurel Glen Drive, when we see those folks coming up, then the state should also have to concede the following. He had that knife in his pocket, and he didn't take it out when those folks came up. And he didn't take it out when he got sprayed in the face with WD-40 or PB Blaster. Forgive me, I have no idea what PB Blaster is. But I understand it's something that you could spray out from an aerosol can. And he didn't use it then either, despite having it right in his pocket. That's a lot of control for a person that they want you to believe is basically a homicidal maniac. He can't be both. Now, when he's down on the ground, you may recall Ryan Hines telling you, again, I didn't feel like he was aiming at you. What else did he tell you about his position? Do you remember? You could see his arm doing this thing, but it looked like his other arm and his bicep were somehow stuck under him, or pinned beneath him. Sure, because he told you he was in the fetal position down on the ground before he was able to get that knife out and start using it. And he had not just Ryan Hines on him, but all those other boys. You can see it in the video. You've got a couple different versions of that video, and I gave you Defense Exhibit B, and I'd ask you to use it, a frame by frame that you can go through as fast, as slow, focus in on a single frame, and you can see that there are two groups that peel off, that there are two folks that are wearing very similar outfits, and those outfits look very much like the lighter bottoms, dark blue top, some graphic on the back, that Jimmy McGrath and Tommy Connery admitted to having been wearing that night. And you can see in some of those frames feet attached to those figures, kicking a figure down on the ground that is clearly not Tyler Da Silva because he's being subjected to a separate beating over to the left. And you heard about how there were two fights developed. That one goes down over to the right, one's going on over to the left. And think about what he's facing at that moment when he's down on the ground, because that's what self-defense requires. Not us sitting here later in the cool hindsight of this room, the ability to say, this, that. No, it's at that moment when you're 16 years old and you're down on the ground and you're facing the entire Shelton High School football team that's pissed off and they already know about the fight at 5 Lazy Brook, right? You heard testimony. They got there and everybody was already asking them about it. One of the first persons that came up to ask Ryan Hines about it was Jimmy McGrath. Griffin Marcinzik told you, Jimmy McGrath's one of the toughest kids I knew. There was already a building fury in that basement. They didn't know about that. This bunch of idiots are in the car. They just got added to a group chat. People are talking shit to them, as they said. People that they claim they knew on social. Can we all agree that if you think you know somebody on social, you don't know that person? I think you guys have all gleaned what a Luddite I am by my inability to
Wait,
work this
Twitter's
contraption
not
over here.
real?
Knowing somebody on social, you just don't know anything about that person. These were all strangers, at least to my client.
I live on
Baker,
Twitter.
You know they're not all
can you
strangers to Tyler
pause
Da
it?
Silva. I told you about growing up with somebody. I told you.
He said you don't know anyone on social, but I think you were sleeping with your eyes open. So I said, oh, wait, Twitter's not real. And Baker's like, no, I'm on it. I swear I am.
No, I'm. Me and Iris are making travel plans,
Ooh.
but we have a few because you want to walk from Cape Town to, I think, Beijing, but I don't want to go to the Middle East or Russia and China. So I'm just asking if we can walk across the Americas, because
Ooh,
I have a
if you
map.
guys
It's
go
like,
to
it's like this
Japan,
wide.
I'm down for sound.
You can't walk to Japan. It's an island. Well, it's a string of islands.
Well, I was just saying you didn't want to go to Russia, China, or other places. Japan wasn't one of those you listed. So,
No, Japan is okay. They're kind of weird, but I would go there. But I'm just thinking I could go visit Brandon, and then I can walk all the way over to the West Coast and see MG.
ooh, Tejas,
No, that's down
tour.
south.
Isn't Iris in Texas?
Yeah, but she can meet me in New Jersey. I'm not going to Texas. They have rattlesnakes.
Fair point, fair point. And chili with no beans. I know it's a Texas thing, but that's just meat and it goes on top of a hot dog. I'm sorry. I know I've probably started a war.
Yeah, but that will be the meetup next year. Will be me and Iris walking from New York to Oklahoma on the West Coast where MG lives. And
Sounds good.
I don't know how. I have a map. America is like this wide, like a couple of days or something like that.
I think so. Okay, but if you guys walk, can I be behind you yelling, "Run, Forrest, run"?
Well, you can send me a text every time Iris got lost again.
Thought they knew cousins and things of this nature. And here they are, texting in the group chat, talking shit. And he says he thought it would be funny to tell them to come over to Trumbull High School because they were going to leave Trumbull High School. And if they showed up, they'd be gone. And then he told you, I saw a picture that got sent on the group chat, and I realized, man, I know some of these kids. He left. He left the group chat. There's Tyler DeSilva, Jack Snyder in the front seat. They're still going back and forth. They're still going at it. Jack Snyder, Griffin Marcinzik are really going at it, right? Griffin Marcinzik is taking photos of the car out front saying sitting ducks. That's what he was facing when he's down on the ground. Not you and I coming up around him and saying, what's going on here, my friend? Perhaps you should not be here right now. This appears to be a bad idea. No, that's not what that video shows. And let's talk about the existence of that video. These kids were ready. They came out with their phones going. This was gonna be a trophy. Just like a hunter hanging a head up on the wall. Let's document this. Let's record this. Not, oh gosh, we don't want this to be going on. This seems a little too violent. Gentlemen, let the young man up. No, we're filming this thing. And we're celebrating. You remember Tanner Chanowski up on that stand? When I asked him, can you identify whose voice that is saying, yes, sir? That was me. That was you? And you're saying, yes, sir. Is that celebratory? I don't know what you mean, celebratory. I don't know. I don't know why I said it. Oh, I asked, did somebody ask you a question to which the answer was yes, sir? Is that what happened? No, I don't think so. No, I don't think so either. And again, how many times did these guys tell you something? And again, how many times did these guys tell you something here that they admitted they hadn't told anyone before? And how often were they telling you, we were all doing something? Everybody just went. I couldn't see this and that and the other. But then on cross-examination, they would tell you, oh, well, yeah, everyone was throwing something, but actually that was me that was throwing something. Everyone was screaming stuff, but actually that was me that was doing it. They wanted to minimize their involvement, generalize what they were doing, anonymize it, and scrub it clean so that they could come in here and tell you, we were just shocked to find this going on. You know that's not true. If you want to believe that, ask yourselves, why? Why do you want to believe that? Sympathy? Do you have any reason not to doubt that when they tell you that? These are people that are filming a beating, not just one. Ricky Fiola's filming too, right? We just don't have that film. Ricky Fiola's over there. He's got the camera out. He's doing this. You can see him in some of these freeze frames that they show you, right? He's like this. And you can almost kind of see when he turns over and he looks at the camera, the light shines right in his eyes. Get that little red. And he's kind of like, oh shit, right? Oh, I didn't realize somebody else would be filming me filming. And then he goes, and what does he do with that? He goes and gives it right to the cops, right? No. He takes it and he shows it to some girls. that we're watching the thing go on. He wants to show them Tyler Da Silva getting beaten because he thought one of the girls would like seeing Tyler get, and he kind of drifted off, right? And I asked him,
But we don't have that video. That video was never saved. So you don't know that you saw red eyes in that
Yeah, and
video.
him do like the little possum freeze, like,
Yeah, the I'm surprised thumbnail.
I love how he's like, and they suddenly got their phones. If you know any teenager, they aren't without their phones ever.
Yeah, but it was a different kids' video we have seen. We didn't see someone with red possum eyes screaming in the middle of the street, "Don't film me." He said because I swiped down, it got deleted. Yeah, he was trying to get into a lady's pants by showing, because we men, we know nothing excites ladies more than handbrake turns and punching each other in the face. That is moisture farming. But sadly,
does,
women don't know that they like it, but we men know that is what you want. So we will always try and do that to you ladies. Maybe even drill some holes in the muffler on the car so it sounds really loud, because women love, they can't hear their music.
You know, it is a turn on.
Yeah, it's funny that women don't know what they like, but we men, we know.
Can you
I'm
finish
glad
that for us?
someone's in
You
charge.
couldn't remember what it was that he wanted to show him for that.
You keep going.
There's no reason to believe that those folks were going to stop unless they were made to stop. And if you tell yourself that there's a reason to believe that they were going to stop unless they were made to stop, if somebody back in that jury room tells you,
10 minutes
no,
now.
he didn't have to do that. They were just going to stop and then let him up. Well, what's the reason to believe that?
Post-marital.
I'm asking, what's the reason
That's
to
what
believe
I have a problem with.
What's the psychology of a mob? What's the psychology of 18 to 20 boys and men? Don't forget, this is a boy at that time.
Boys
Some
to
of those
men?
folks there were men. They had already graduated. Right? They told you. Taylor Capella told us. It was mostly older kids there that night. What is the psychology of a mob? The problem with the mob is not what they do as much as what they might do. Because you don't know what they might do. So when you're down on the ground, you're getting kicked and punched and stomped. And again, we know there's at least 15 to 20 people there. It doesn't matter what these witnesses got up here and told us on the stand as far as saying, no, it was just a one-on-one, or maybe it was two of them talking with them. That's just simply unbelievable based on what we see there and what's going on that video. And we heard a little bit from some of the witnesses trying to tell us Raul's there on the lawn beside Tyler Da Silva. They're facing this big group of Shelton High football players that have started to circle them. He's not got the knife out, but he's going to pull back like he's cocked and ready to punch somebody. And who was that supposed to be? Ty Woods? You didn't hear Ty Woods tell you that, did you? No. You didn't hear a thing from Ty Woods. You heard the people that are trying to protect themselves from what they did tell you that that's why Tyler Rich just had to haul off, even though he was over here talking to Tyler Da Silva, and punch Mr. Valle, who again still had not pulled out a knife, even though he's got it in his pocket. Didn't even pull it out to say, "Hey, whoa, guys, this is looking a little dangerous here. I think maybe you should all know, back off." No, at that point, Tyler Da Silva's still thinking he's going to make peace because he knows somebody's cousins. They know his cousins. Ricky Fiola and Tanner Chernowski are proof that everybody there knew what they were planning to do because they had their cameras ready to go. So those are the kind of folks that are kicking and stomping and punching Tyler Da Silva and Mr. Valle while they're down on the ground. And the first three folks that get stabbed, look at their wounds. Again, face on teal. He told you, well, I was sort of over on the side, and then I came in and I started getting in a few, what did he call them? Light stomps? Medium stomps? You ever been medium stomped? Anybody? What's a medium stomp? A stomp is a stomp. A stomp is somebody down on the ground. You don't stomp somebody who's standing up, do you? No more than you stab somebody in the legs unless you're down on the ground. Look at those wounds. One to the back of the leg. A couple to the front. Those are wounds that you give somebody when you're down on the ground. You don't bend down and give a couple here and a little there, and then we get one in the back. It's just not how that happens. It happens fast because you're frightened and you're panicked and you're scared and you have a reason to believe that you've got to do that because nothing else is stopping them. In fact, you heard Mr. Valle. It scared him even more after he had to do that because it didn't stop. And you've got Ryan Hines. Look at his injuries. One to the ribs. What, when you're over top of him? When you're punching him in the face? Then further down on the side, and finally one down on the hip flank area. Again, what did he do? Mr. Valle was standing with him and went, one here, one here, one here, one there. It makes no sense. It's not the way this happened. It's not the way self-defense happens. Again, it's not complicated. Doesn't mean it's not hard. Doesn't mean it's not difficult, the decision that you have to make. But it is not complicated. It is simple. He's down on the ground. He's getting beat. He's getting stomped. The same thing is happening to his friend. Nothing is telling them that that's going to end unless he makes it.
I better proofread that because he writes
So with
like
his
a
arm pinned
moron.
behind him while he's getting stomped and kicked, boom, Ryan Hines. Tommy Connery tells you he comes
He's
over.
not going to
and
name you.
separates
He's
them,
just
right?
going
He
to say
takes his place.
foreigner.
Takes his place over
Yeah.
top of him. Pounding him on it? No,
Idiot,
he's over there
fat
as well,
idiot.
getting in his kicks. His leg gets stuck, gets the side, the back, right? Now Ryan Hines tells you after he got stabbed, that was it. He had nothing to do with what happened to Tyler Da Silva. You know that's not true because you saw that video. You saw that green hoodie, black shorts with the white trim right over there on top of Tyler Da Silva, kicking him and stomping him with the rest of the group. Part of the state's argument here is simple. Who are you going to believe? Our
Ghostbuster.
witnesses or your lying?
Hillary Clinton, as always.
Look at the video. Watch it, and you will see there are two groups here. You will see one group breaks off. That's the group that is beating on Mr. Valle, and then you can see them shove him into the road. He walks to the car. Thank goodness at that point Tanner Chernowski was filming. Because what do we see? Camera pans over. He's looking. What's he looking at? He's looking at where Mr. Valle is. Mr. Valle's by the car. He opens the door briefly. You see the light come on inside, the interior light. And then you see his head go just like this. Right? And we can see the side of his face. We see the profile. And you can almost hear the wheels clicking inside Tanner Chernowski's mind. It's like, what's he looking at? You see the camera pan again. Boom. What's that camera pan right to? Tyler Da Silva on the ground, surrounded, getting pounded on by a number of kids, right? Kids that are saying, yeah, come on, get some. Who wants a piece of this? Yes, sir. That's what's going on. Any indication those kids are going to just stop that at that point? No. Not a single reason to believe.
Thank you, Holly Mac. Yeah, I'll need some ibuprofen after this one. I know he's doing his job, but as someone said, write an outline, stick to it, and doth protest us too much. Tiny Hands McGee here keeps a handle on the back of his head because he can slip out of his fuzzy restraints.
I think he's implying that he gets, he likes to be restrained with fuzzy handcuffs.
Oh, the pink handcuffs.
Yeah. I will say that I can make my hand very small and usually slip out of them as well. But that's because we have the same size hands, only I'm a girl, so it's okay.
Yeah, and men like females with small hands. It makes things look bigger.
You know, I never thought of it that way, but
They didn't stop with my client until he had used that knife. And they gave him no reason to think that they were gonna until he used that knife. That knife was a tool. It was the only tool that he had available to him. to survive.
are you a tool,
That was the specific
sir?
intent that he had. States charge specific intent crimes.
Someone
Again, they're
think
right
of
about
the
specific intent.
jury.
But it's not specific intent to murder. It's not specific intent to assault. It's specific intent to survive.
No,
Because he had no reason to believe.
Brandon,
That was going to stop.
he's
They were intent
in surgery. His
into unconsciousness at best.
dog jumped off
Serious
his
physical
bed
harm,
and peed on him.
almost certainly. and no way to know whether or not that was going to stop until he was dead. Just not. If you want to believe otherwise, ask yourself why. You're going to get an instruction on implicit bias. Is there something about the way my client looks, the way I am, that makes you think he's any less believable than those kids? That he deserves
No,
to have
it's your
self-defense available to
closing.
him any less than any one of us? That those kids, if they were down in that same position, wouldn't have done that exact same thing?
It's too
Would it
fast,
change your mind
too fine.
if he'd had a screwdriver with a 3-inch shaft in his pocket and that he pulled that out and used it? He'd have the same wounds, stabs and punctures. This is what self-defense looks like. Most of us have never had to think about that before, right? What does self-defense look like? I don't know. Maybe I saw it in a movie or something. There's no manual for self-defense. When you're down on the ground, there's no handbook that you can pull out and be like, page, getting stomped by group of, how many of you are here?
What is this?
It doesn't work like that. The law doesn't require you to go through
He
that.
thinks he's a YouTuber. That's what I do.
You'd be dead.
I
Maybe that's something that you've never thought about with the law. But I asked you guys, I know I did. Can you follow the law?
he has an
even
arts
if
degree.
you don't like it?
Bless his
And I probably
heart.
gave you
Just
some
bless
ridiculous
his
example,
heart.
like have you ever heard the song, I Can't Drive 55? There's a guy who doesn't like the speed limit rules, and he says he can't follow. Well, this is a lot more serious than that, right? This is, can you follow the law even if you don't like the fact that somebody died? But the law is, you just have to make a reasonable choice. Did he have a reason to do what he did? Yes. Do you have any reason to doubt that? What is it? Because Tyler Da Silva told you that the fight was over when he got back over there? You saw Tyler Da Silva in that video. He didn't think the fight was over. He's in the street, hitching up his pants, facing back towards the group. We can't see Raul at that. Tanner's perspective is over here. We can see Jimmy McGrath a little bit on the side. You heard Mr. Valle tell me. They were forming a semicircle. They were forming a horseshoe.
There was
And I
enough
asked
room to
all of
leave.
those witnesses, watch that video. Where did those kids go? Where was Charlie Connery coming from? Followed by 1, 2, 3, 4, 5 kids. Who were those kids that were following him? One of them was Matthew Lockridge. One of them was Jimmy McGrath. Where were they coming from? Watch that video. Use the frame by frame. Go through that part closely. You'll see exactly where they were coming from. They're coming from just having been involved with the fight with Lito that shoved him out into the grass, out into the street. That's exactly where they're coming from. Now, he didn't have time to identify anybody. He didn't know Jimmy McGrath. That's probably the tragedy, the most tragic thing of this whole thing. These kids are practically strangers, at least when it comes to Mr. Valle, as to all of them. With a stranger, you can't know. What is that person going to do? You have to make your decisions based on the information that they're giving you at that moment. Again, what's the information that he's got? These are kids that are going to attack the car. These are kids that are going to stomp, kick, punch, gang up on, film it, record it. For what? I asked Tanner Chernowski, why are you recording this? Oh, I don't know. I just do that. And then at some point he
13
admitted
minutes left.
to collect memories.
I can take a pee break before I have to
He thought this
entertain
was going
during
to
the
be a
break.
memory that he wanted to keep.
I'm not going to miss anything.
Before he knew what the tragic outcome was. But when he thought it was just a beating and an assault that was going to go on, yeah, that was a memory he wanted to collect. That's who Tanner Chernowski is. That's who these other kids were. Now, some of you might be thinking, well, when he comes back onto the grass and he passes by Tyler Da Silva, at that point, you know, I can't see any of those other kids that are there. I just see Tyler, and then I see a little bit of Jimmy. Well, you see a little bit more than that. See that hand? Look at that hand down here around the back on Jimmy? It's not his hand. It's Matt Lockovich's hand. Because they're side by side. Because they are part of a semicircle. This is a group that has been acting as a group the entire time. You're telling me all of a sudden this group has decided, oh, let's split up, let's single out. No. And in fact, you can see in the video across the way, there's another person on the other side of Mr. Valle. He's got on a dark top and there's some sort of white lettering across the top. You may remember I was trying to point that out. If you're going to have that evidence, take a look at it. And ask yourself about perspective, right? Because when we're looking at things one way, we can see it like this, and these things appear to be very distant and far apart. But if I shift over here, Now it looks like something else is in front. And ask yourself, wait a second. He steps into that place. These kids are all around him. They don't just disappear. And you say, okay, well, hold on. Charlie Connery's yelling, he's got a knife, he's got a knife. These kids are all backing up, right? Makes perfect sense, right? Thank you, Charlie. You solved that one for us. I think he did, inadvertently. Do you tell somebody who's running out of a house fire, fire, fire? I got to warn you about the fire that you're running away from. No, you don't. You warn somebody about a danger that they are running into. And that's exactly what was happening here. He's got a knife. He's got a knife. Guys, don't go rush him. You need to back up. That's who you warn. You don't call off people that are already calling themselves off. Again, that just doesn't make sense. And you don't have to believe those witnesses just because it's their friend who died. You don't. And you shouldn't. And you wouldn't under any other circumstances. Some of you have experience doing workplace investigations. You know this is way more serious. These stakes are so high. Why are you going to believe these witnesses and this evidence under circumstances like this when you wouldn't believe these folks, knowing what you know about them, their selective memory, their efforts to minimize and generalize and anonymize, not put themselves or their friends in any danger? Lay it all on him. So your duty is to look at this situation, the circumstances that my client faced as they were at that time. It's at least 20 versus 2. It's at least that. Could have been more. Some of these folks told you, oh, well, there's people watching. They're just sitting. They're just watching. You want to believe that? There's probably nothing I can tell you or should even argue to you. These folks had sprayed WD-40 in his face. These folks, 20 versus 2. That's 40 fists, 40 feet and legs. There's nothing that says the force he uses to defend himself under those circumstances has got to be identical. Just because they have fists and feet doesn't mean he can only punch and kick back. That's not what self-defense requires. It simply requires reasonable. Is it reasonable to use a 3-inch pocket knife that you didn't bring, but that you have in your pocket because your friend gave it to you? Under those circumstances? Of course it is. Look at these wounds. Jimmy McGrath, 1 wound. That's it. He's not trying to stab him over and over and over. He steps into this situation. Look at the amount of time between the time he steps onto the grass. And again, perspective. They want to try and tell you that that kid on the far side of him is not lined up with Mr. Valle. Look at the grass underneath their feet. Valle's on the grass. That kid's on the grass too. The line of the curve goes just like this. You know about horizon and perspective? They're almost side by side, those 2 kids. The other kids haven't gone anywhere.
What?
It's wet. You remember me asking all these kids, is it dark, wet, rainy, misty? I don't remember. You can see it in the video. You can see rain beating on the windows of the cars. Of course it's wet. And you heard Taylor Capella tell us he came onto the grass and he slipped. He spun around. And Mr. Valle told you he got punched. Somebody swung at him. Did you see Matt Lockovich's hand on Jimmy's back? And all of a sudden it's gone. You can infer what happened there. Matt Lockovich takes a swing at him. And Mr. Valle told you, I just swung. I put everything I had into it. I was terrified. These kids hadn't stopped before when they were stomping me and I had to use that. They weren't stopping now. Did he have a safe retreat that he could completely and safely retreat? Of course not. Last time that he had tried to get up, these kids tackled him and went down again. And here they were coming again. And we know they were coming again because we hear them being warned. He's got a knife. He's got a knife. Again, you're not telling that to somebody who's not walking towards that danger you're trying to walk them off. Who's not rushing towards that person once again. Mr. McGrath is holding the edge. These are all football players, right? They know what it means to hold the edge. He's holding the edge, that horseshoe, that semicircle. He is a threat just as much as anybody else in that mob at that point. Those are the circumstances that Mr. Valle was facing. That's what you have to judge him on.
There was no horseshoe.
You've heard about consciousness of guilt, right? Why have we heard this evidence about consciousness of guilt? It doesn't change anything about what happened down there on the ground at that point. It's just another effort to make my client look like some sort of criminal mastermind. He knew to go out and throw the knife into the woods. Well, let's talk about that. Who told us that that's what happened?
How
Only one
slung
person.
to die of
Jack
testimony?
Snyder. When he's in here singing for his supper, the jailhouse keys ringing in his ear, he's trying to give you something, trying to give the state something to believe him. Oh, they haven't found a knife. I'll tell him he threw the knife down at the end of Adams in the cul-de-sac. And then Shelton PD.
No time
Rango
limits.
tells you, "Oh, we went out, we looked for the knife, couldn't find it. No knife. I guess that means Jack Snyder must be true. I guess Jack
An
Snyder
hour
must
and
be
20
true
minutes so
now
far,
about this.
but we are
Tyler Silva didn't tell you anything about that. He's in the car.
2-3 minutes
It
away.
stops. Nearly hits his head on the back seat. He's screaming at Jack about something. 1 or 2 seconds later, Mr. Valley hops back in the car. Mr. Valley told you. I got out of the car. I was feeling some pain. I looked at my ribs. He didn't tell you that he had the knife or that he did something with it. He told you he lost that knife, right? And he told you he lost that knife as he was running back, trips and falls. And what's he got on his hands? You've seen it. He's got 2 big, nasty strawberries on the heels, palms of his hands, exactly like somebody would have when they fell to the asphalt. Like it looks like road rash. And he lost the knife at that. Do you have any more reason to believe Jack Snyder about anything, let alone that? Of course not. Ask yourself, if you want to believe him, why? Why do I want to believe Jack Snyder so badly? He's not giving you any reason to believe him. The text messages. Again, here's my client, a criminal mastermind, conscious of guilt. So he's texting with his girlfriend, who's also, no, she's 17. He's 16, she's 17. They're texting back and forth. Like he's going to convince her that he wasn't there. That doesn't make any sense. He was panicked. He was still scared. He had no idea what had just happened. Look what he'd just been through. He's not going to convince her that I wasn't there. And then he goes to Florida. He's 16. He doesn't go to Florida because he's trying to get away from things and he knows that he can go down there and escape. I don't even know if you can get on a flight when you're only 16 years old. But he gets on that flight because that's what his parents told him to do. And that's what
No, they actually didn't. The plan was him staying.
you do when you're 16. Your parents tell you we're going to Florida. It's not a mastermind move on his part. It's just trying to make him look bad.
Stick to making him a
He don't need any
dumbass.
help looking bad. Okay. Again, bless his heart, there was a whole lot of stupid going around that night. That's my client.
I'm dead.
Yeah, that's
Ellie is no different than any of these other kids. And if you're telling yourself for some reason that you think that he is, ask yourself why. Look at the situation all these kids were in that night. How did they get there? These kids at 43 Laurel Glen Drive were like torches. My client and his friends, they were like straw. Throw those torches in there, put them all together. There's absolutely no way to know what is going to happen as that wildfire starts to catch and goes round on the front lawn of 43 Laurel Glen Drive. But he certainly knew as he was down on the ground that folks weren't stopping with the stomping. They weren't stopping with the kicking and the punching. So he used that knife, a tool to survive. If you're down in the bottom of a hole, dirt's being shoved on top of you, you're going to use a shovel to climb your way out. That's what he was doing there. You
You
have
had
every
the
reason to
shovel, you
believe
dug
that.
the hole yourself.
Or a little bit over, so if you wrap it up.
oh,
Thank you, Your Honor.
so he had a timeline.
Folks, I'm not going to apologize for taking up a little bit more time. I do want to thank you for listening. I hope you will look at that evidence. I hope you will take your time with it. I hope you will all understand this is probably the most important thing you've ever been asked to do in your lives. And I will tell you that the law requires you, despite the tragic ending in this case, the law requires you to find my client not guilty. Thank you.
What?
He started out okay, And then he went into
Yes.
the other kids are at fault. And then he ended up by saying the other kids were torches and they were straw, and no one knows what that. Well, everyone knows what happens if you throw a torch in straw; it starts a fire. But why did the straw go back to the torches? That's what the jury's going to sit there and think. They're not thinking, "Oh yeah, all those kids were a fire hazard." You don't go into Florida when it's burning season. You just stay out.
Well, and I don't think that attacking the victims and saying, why do you believe them and you don't believe him? I would have said, hey, the stories don't match up. And every time I question them, they had either different or, new information. You guys are the finders of fact. Do
Yeah.
you find it interesting to say, that they're siding with the state? Again, he's doing the same thing the state did, only in reverse. He is, trying to put on these children that, we're going to all get together and work with the staties, and then we're never going to get caught. I mean, again, they were probably worried about cover my own behind. They didn't have some grand, scheme to work with the state to, get this boy because they don't like his curly hair.
I have no idea what he tried to do, but it was bad. But everyone, sadly, we have to say, hola Mo, because Mo couldn't stand this anymore. She has been calling a 1-800 number. They will put her on a list right now.
Yeah, I'm actually going to talk to a closet designer. I didn't even know that was a thing, but apparently Mr. Mo decides we need a closet designer.
I came out of the closet last week, according to the aunties. So I'm a closet expert.
Well, it is your month of June, and I salute
It's
you for
July.
being brave.
It's
Well,
the
but
3rd.
last week was June.
Yeah.
It was your month. Go, sister,
That's-
go.
That's why. Thank you, Mo, for hanging out with me and helping me get over the transportation problems today.
No problem. Have a great day, and oh my gosh, I'll pray for all of your souls and bless your heart. Although I feel like a semi-Appalachian, like, I don't like you Northerners using our terms. I kind of feel like that.
Well, I don't know, because I've been looking at his website. He has some. He got a bachelor's of arts degree in English with honors in Davidson, North Carolina.
And yet he can't put together a cogent line of thought that's easy to
Well-
digest.
Maybe that's why he didn't follow along with his master's in education that he got from Hunter College in Manhattan.
God. He could be your kids' teachers.
And
Have
he
a
didn't
great day, you
get.
guys.
This is the picture. This guy plays
Steven Seagal.
he
when he was
plays a
skinny.
chaotic neutral spellcaster in D&D, and he's the guy who always said, "I thought the rest of you checked for traps. Why am I dead again? Because you're the spellcaster. Cast a spell to check for traps. But I got my magic missile."
He has a cloak in his closet. On that note, I am finally leaving.
Go to your closet and put a coat in it. See you all later.
True. Bye.
Good afternoon. This is my second opportunity to address all of you. It's funny that I'm listening to counsel's argument about there was a lot of Tyler DeSilva, Jack Snyder in there. This case does not rise and fall with Tyler DeSilva and Jack Snyder. The warrant was signed, you heard from Detective Bango, on Monday the 16th. So the warrant was signed. There was enough probable cause at that point. And the investigation was still unfolding. But there was enough to arrest the defendant for what he did that night. Tyler DeSilva and Jack Snyder approached us 6 months later because they had information. And they want you to discredit everything that Tyler DeSilva and Jack Snyder said. But you have to look at it. Remember when we, during voir dire, I asked all of you, how do you determine credibility? Are you just going to sit there and look and hear, you listen to what they have to say? What's their demeanor? But isn't it, use your common sense? How does what one witness say, how does it marry up to other witnesses' testimony in the entire case? Tyler DeSilva and Jack Snyder are not the only people that heard the defendant ask for the knife. Keenan Frasick did. Demetrius Arfanis did. Mackenzie Traficante heard somebody asking for a knife while she's walking away. There are other people that heard these things. So again, whether or not you're ready to just discredit them because they have an immunity agreement with the state of Connecticut, I suggest to you, see how the information they provided to you in this case marries up with the rest of the case. And I would agree with the defense that there was a lot of stupidity that night. Absolutely. But the bottom line is you can't bring a knife to a fist fight. You just can't. Look at the defendant's injuries days after the incident. He's not completely beat up. It's because he took the knife out immediately and started stabbing people. You would think he would have huge contusions all over his head, and he didn't even go to the hospital. I would submit if he was that badly beat up and the only way out was to, I could not, I had to fight for my life. But the physical evidence does not show that. And there was testimony, his arms pinned under his body. How did he get the knife out with one hand and open it up with one hand? I would submit that's next to impossible unless you're a pro at it. I think the more likely thing that you can infer from what happened is that he took the knife out of his pocket while he was involved in the fight immediately, opened it up, and started stabbing people. He wasn't on the ground like they would have you believe. He went after Tommy Connor. He stabbed Ryan Hines in the chest. It's just not reasonable to bring a knife to a fist fight. He went there looking for trouble. That's the bottom line. Because if he doesn't go back, none of this happens. But he went back. Imagine if he didn't go back with a knife, it would have just been a fist fight. That's all. But he went back with a weapon. You can't use more force than what's being used against you. And the defense would have you believe that being punched is deadly force. It's just simply not true. By the way, they want you to discredit everybody that has testified in this case. This is not a whodunit, and they agree it's not a whodunit, right? He used the defense attorney used that parking lot example. I was actually thinking about this during the break. You know, the kids that testified, they saw what happened, right? It was chaotic, but they saw what happened. And when they go and they give a statement to the police, you know, will they ask who was to the right of you, who was to the left of you? Probably not. Did they know at the time? Maybe. But now it's 3 years later, right? So it's kind of like a situation where you're in a parking lot and you park your car. Now, all of you came here, you parked your car. Did you look to the right? Did you notice what color the car was next to you? Maybe some of you did. Maybe some of you didn't. But you knew you parked next to a car, right? Now imagine that happening, and then you see somebody being chased in the parking lot and get stabbed with a knife, right? Now that's a horrific event that you've just witnessed. And you give a statement to the police, right? And you see, you're not going to say something like park next to the red car. Maybe you remember that at the time. So now fast forward 3 years later, I guarantee each and every one of you would recall that horrific event happening. But if you got on the stand and I said, well, what color was the car to the right of you? You can't recall. What color was the car to the left of you? I can't recall. Do you know if there were cars next to you? Yeah, I know there were cars next to me. I just don't recall what color. So the reality is the color of the car or the person that was standing next to anybody necessarily in and around that area in this fight, this chaotic scene, is that important in the grand scheme of things, right? Does it make a fact and evidence more or less? Probably not, right? Because listen, there were a lot of people around, a lot of people were watching. There was 2 or 3 kids fighting at any given time, right? We've seen that. We've seen the video. But does it really make a difference if, you know, Taylor Capella told she was standing next to who? Michaela Holt, right? She remembered her. Maybe there was somebody else next to her. She can't recall. Tommy Connor was standing in the driveway at any given time when the car first arrived. Yeah, I knew I was there. I was talking to people. I just can't remember exactly who I was talking to. But does that really matter in the grand scheme of things when we know the car arrived at 43 Laurel Glen? There was this confrontation. The car was shook. The car was hit, and they took off. And according to people inside the car, it was scary. We didn't want to be there. We wanted to get out of there. And the defendant told you that. Again, assess his credibility, because when he's down the street, he arms himself with a knife and comes back. If you're really that scared, why would you go back and confront 30 kids who just shook the car? I mean, that makes no sense to me. So, I mean, look, the defendant was angry. We don't know why he was angry. It's because the car, we've heard testimony about that. It's because, you know, these kids really messed up the car and he was pissed off, and it was almost like they one-upped him. He had already had one up on Ryan Hines back on Lazy Brook because he tuned him up with the helmet after he sucker punched him from behind. But now that they disrespected Jack Snyder's car, let's go back. Let's go back. If things go sideways, guess what? I got a plan B. That was the plan. Might have been a stupid plan, but that's what happened. That's the bottom line. This is not something that happened, I mean, I would say instantaneously. As soon as he gets hit, he takes the knife out. He's not waiting to get pounded on. No, there's no way. If he was getting pounded on the way the defense suggested he would have more injuries.
A single punch can still be enough to instill fear and make him pull it out. One punch can kill.
We'd have seen after the fact, and he simply did not. And by the way, the defendant testified when he was running out of there after he stabbed McGrath in the chest, he dropped the knife. The cops looked for the knife all in that area. They couldn't find the knife. They actually walked up and down the street. They held the area. They looked for the knife the next day. No knife. And the information that Jack Snyder and Tyler DeSilva gave us, right? We didn't know where the knife came from. We knew the defendant had a knife. We didn't know
He
how
forgot he
where
had a
it
son
came from.
now.
Jack Snyder gave us that information. He came to us. We didn't go to him. But even if you take DeSilva and Snyder out of it, it's still the defendant going back to 43 Laurel Glen with a knife. There were people in his car that he went to high school with that heard him ask for a knife. He went there. He got out of the car. He went in and provoked the fight and instigated the fight. And it started. He took it out and started stabbing kids because that's what he wanted to do. And then once he was able to get out of there, he went back in for more. And they have to have you believe that he was being approached or surrounded when he came back into the fold. He has a duty to retreat. You can't come back into a fist fight with a knife. It's just not reasonable. It's not reasonable. Even if you believe that self-defense applies to the first 3 kids that are stabbed, even if you believe that, it certainly does not apply to Mr. McGrath. Because again, self-defense is not retaliatory. It's not punitive. It's defensive. You can't.
Go on sub to his channel. Don't have sub. I just hit 17,500. Don't take that away from me now.
You can't do things like this and then turn around and claim self-defense.
Female prosecutor.
From the car.
It's annoying.
Charlie yelled he's got a knife. And within seconds, he turned around and stabbed McGrath in the chest. They want to have you believe that he slipped. He slipped. It was a purposeful stab in the chest, right? So again, when we're talking about intent, specific intent, the areas of where the wounds were inflicted, right? The number of wounds inflicted, the defendant's manner and how he conducted himself that night, both at Lazy Brook and later that night, he did not have to go back to that house. It's as simple as that. He did not have to go back. But if he was going back with a plan B. That's as simple as that. And that conduct cannot be excused. It's a horrific event. It's terrible. It's a tragedy. That cannot happen. Because if that happens all the time, then this is a very different world we live in. And I asked him on a cross-examination, when you got out of there and you left and you went home, after you texted Mackenzie, you didn't call the cops at that point, did you? Nope. You went to Florida, right? Yep. Did you call the cops when you're in Florida? Nope. After you learned the severity of the situation, did you call the cops and tell them, hey, this is what happened. I was pummeled. I was acting in self-defense. Nope. So again, I would submit to you that, yeah, he knew what he was doing. And as soon as he stabbed those kids and he told Jack, and they got out there and they went down to Adams Drive and he got rid of the knife. Why are we getting rid of the knife? Call the cops. This just happened. It's horrific, but this is what got rid of the knife, got rid of the evidence. Tells his girlfriend I wasn't there, didn't want to put anything in writing, God forbid. So he said, yeah, you know what? I was really getting pummeled. I had to stab those kids to get out of there. I was really fighting for my life. Didn't say that in the text. Just said, no, I wasn't there. It wasn't me. I don't know what you're talking about. I wasn't there. And then he told Tyler DeSilva subsequent to that he messed up. He knew. The judge is going to give you, the self-defense instruction. And again, it's only justified when a person reasonably believes that such force is necessary. Reasonably believes. The first thing he didn't do is he didn't punch back. He didn't kick. Grab that knife. Again, you're going to hear the judge instruct that a person must not use more force than he reasonably believes is necessary. I would submit on that night, he used more force than was reasonably necessary. And I submits that we've proven that beyond a reasonable doubt. We also submit that he provoked the fight. You're going to hear some disqualifiers. If you believe the state has proven the disqualifiers, one or all of them, doesn't matter. If you believe we've proven those disqualifiers beyond a reasonable doubt, then he cannot avail himself of the self-defense claim. So in a provocation, you're going to hear the judge instruct that a circumstance under which a person is not justified in using any degree of physical force in self-defense against another person is when he provokes the other person to use physical force against him. The defendant must have specifically intended to provoke another into using physical force and then use force to defend himself from the ensuing force that he provoked that person to use against him. You're also going to hear about the initial aggressor. The instruction that with regards to that is another
He's gonna
circumstance
read it in
under which
5
a person
minutes.
is not
Stop
justified in
reading
using
it
any
to
degree
me.
of physical force in self-defense against another is when he is the initial aggressor in the encounter with the other person and does not both withdraw from the encounter and effectively communicate his intent to do so before using physical force. He also has a duty to retreat. You're going to be instructed that 2 conditions must be met. A complete safe retreat is available to him, and he knows he can avoid the necessity of using deadly physical force by making complete safe retreat. Self-defense cannot be retaliatory. It must be defensive. It's not punitive. You know, it's again, if you look at if you look at everybody's testimony, they would need you to disbelieve everybody's testimony in this case for you to not find that the state is proven this case beyond a reasonable doubt. If you look at Jack Snyder and Tyler Silva, took them out of it and just listened to everybody else testified, I would submit that there is more than enough evidence to determine that this defendant brought a knife to a house he shouldn't have been at, and he used that knife. He shouldn't have. And after he used it, he went back in and he stabbed McGrath for no good reason. But I would submit that he formed the intent to kill him when he turned to him and lunged at him and stabbed him in the chest. You heard the testimony of the doctors, of the medical examiner. These were not slash wounds. These were puncture wounds, purposeful puncture wounds. You know, the fight lasted about 30 seconds. You heard evidence of that, 17 of which it was video recorded. I know defense counsel wants to point out that McGrath was involved in some of it. Unclear. You're the judges of that. But even if he was, like I said before in my opening remarks, self-defense cannot be retaliatory. You can't come back and say, well, listen, man, you were pushing me into the road. Sorry, I'm going to stab you. You can't do that. I mean, what kind of world do we live in? No, yeah, it's not right that there's fistfights. It happens. But, I mean, look, Tyler DeSilva was getting beat up, but he wasn't getting completely demolished. I mean, at some point, they threw him out in the street, and they said, get out of here. It was over. And, you know, and Ryan Hines, Faison Teal, Tommy Connery, they came in and they told you what their part was in the whole situation, right? Tommy Connery, I would submit, there's no self-defense claim against him. He was trying to get in there and breaking things up, pushing him away.
And he should be. But he should be. I think he should be tried as a juvenile, and he should only be charged with manslaughter. Even though I could also make the argument for murder, I still don't think he wanted to kill.
Why did he deserve to get stabbed? And I would submit Ryan Hines. Yeah, Ryan Hines said I hit him punched him a couple times, but that's his fist. It's not a knife. If Ryan Hines had a weapon, it would be a different story. If Faison Teal had a weapon, this would be a different story. If Tommy Connery had a weapon, this would be a different story. If Jimmy McGrath had a weapon, this would have been a different story. But the bottom line is you can't escalate the fight. And that's exactly what the defendant did. Counsel indicated on his closing argument that Tyler Rich wanted him on the lawn. That's simply not true. And we have evidence of that down at 36 Laurel Glen. They ran down there. They're arguing back and forth. Things are being thrown, but there's no physical altercation. Why would you? Yeah, let's wait and see if they come back. Let's fight on the lawn. I mean, just have the fight down the street. They didn't fight down the street. That's the whole point. They wanted them out of here. Again, the judge is going to instruct you on what specific intent is. And no, there's no particular time necessary, no length of time necessary to form the intent. I know that counsel, did he wake up in the morning? Yeah, I'm going to go kill somebody, stab some kids. Of course not. Of course not. But if that were the case, if we had to prove that somebody woke up in the morning saying, I'm going to go stab people or shoot people or kill people, then we would never be able to prosecute anybody because that's a tough thing to prove. And that's the point, because it's the conduct at the time that it happens, right? That's how you can infer what his intent was. He created the specific intent when he decided to take out that knife and escalate the fight and stab you. And you heard everybody testify. I think I asked every person that testified that, when you were involved in the fight, did you have a weapon? What did you witness about the fight? Did you see anybody with weapons? Nobody had weapons there. It was a high school fight. A high school fight that the defendant escalated. And the interesting thing is, defense counsel didn't really spend much time on Taylor Capella and Charlie Connery. Those are the two individuals that actually saw the defendant. stab McGrath, right? Turn to McGrath and lunge at him. Who was Charlie standing next to? Do you think Charlie wasn't, a lot of these kids, they were kids at the time. Their memories maybe have faded a bit. I don't recall exactly where, Ricky Fiola was at any particular time. I don't recall if I was in the basement, on top of the basement, outside the basement. But the story is the same. The horrific event that is etched in their minds forever is the same. They recall this defendant who had no right to be there, come back to that house and stab 4 of their friends. This is not about protecting people. They got to understand, yeah, we were underage drinking. Yeah, there was a fight. People were punching people and it wasn't right, sure. But who are they protecting? Who are they protecting? They just came in here and told their story from their perspective. And does it mean that?
I think so too. I think it would be an unfair verdict. But again, jurors want to convict. A kid is dead. I think he's been overcharged and he's charged as an adult, which I also think is too much. Juvenile manslaughter would have been a fair verdict in this trial.
Because one person's perspective as to where they were standing or who they were standing with, and the other person doesn't remember them standing next to that person, does that mean that it's a lie? Is the defense would have you believe? I would say no. Because if you don't recall sitting next to each other a year from now, but you recall me arguing to you and the defense attorney arguing to you, that's all that matters, right? Because it's what you're perceiving here, not really in your periphery necessarily. I mean, you may remember it, but does that matter is the question. Does it matter who was standing next to you at any particular time? And the defense attorney wants you to ask yourself, does a lot of it make sense? And the thing that I would submit to you that doesn't make any sense at all is if you were truly, truly scared of the 10 to 12 to 15 to
Judge.
20 kids that just rocked the car and threw stuff at the car, if you were panicked, why would you go back and want to confront them? At the end of the day, that makes 0 sense. It makes 0 sense unless you had some courage in you, and you had some courage in you because you had a weapon. That's the only reason that would make sense. Because he went there, he had the intent to hurt somebody there, especially if the fight got physical. They want you to believe that the knife was the only tool that he could use to survive. I mean, he's not in the Amazon. This is a high school fight, fist fight. That wouldn't have happened, by the way, if he didn't go back. The only kids seriously injured here were Ryan, Faison, Tommy, and Jimmy. He didn't get seriously injured. You can't bring a weapon to a fist fight. You just can't do it. And to excuse this conduct would be just wouldn't be right. Self-defense cannot be punitive. It has to be defensive. At the end of the day, that's what this case is about. And that's what they're hanging their hat on. They want you to find self-defense. Because they can't hide around the fact that the defendant brought a knife to a fist fight. That's in a nutshell, that's what it is. So you have a tough job, absolutely, because you have to look at every element of the charge. The state proved it beyond a reasonable doubt. Did we prove specific intent to cause serious physical injury with a weapon with regards to Hines and Tommy Connery? Did we prove the specific intent to cause physical injury with a weapon for Faison Teal? And did we prove
Twice
that the defendant had the specific intent to kill Jimmy McGrath and cause his death? I submit to you that if you look at the conduct of the defendant, bringing that knife back, he could have left the knife in the car. He could have not taken the knife from Jack. Think about that. But he didn't do that. He brought the knife with him. If you look at that conduct and you're questioning, well, what was his intent? I mean, you have the Laserbrook fight too. Didn't need to helmet Hines, but he did. He helmeted the kid and then got up there and told you a different story. I think after you look at all the evidence in this case, cold, hard look at the facts, we're confident that you're going to find the defendant guilty of the murder of Jimmy McGrath, assault in the first degree for Ryan Hines, assault in the first degree for Tommy Connery, and assault in the second degree for Faison Teal. Thank you very much for your time.
Thank you. Ladies and gentlemen of the jury, yes, you have heard all the evidence that you are going to hear, and you have heard closing argument. However, you have not heard the defense instructions regarding the law that you are going to the fact that you find in this case. As you are not yet at a position to discuss this case with anyone, including your fellow jurors, okay? So you do obviously still remain duty bound by the conduct of your juror's oath. and the rules of juror conduct, so do not discuss this case with anyone in the room. Remember the rules that I went over with you day to day. We are going to move into our lunch break. After our lunch break, I'm going to come back onto the bench, do a few administrative things, and then I am going to have you brought back into the courtroom. And at that time, I will provide those instructions to you, otherwise known as the jury charge. So enjoy your lunch, get a little bit of extra time after lunch. You'll hear the charge. You'll hear from the after the charge at some point in time later today. I expect that you will begin your deliberations. However, now is not the time. Okay? Thank you so much. Have a good night.
All right. So, everything's done. Everything's over. They just need to be instructed on the jury instructions. She claims she will have them have the case today, but jury instructions will be at least an hour and a half. Then it's 3:30. She goes to 5. I'm just thinking, is it worth coming back after? Or is it just going to be me sitting here wobbling along for nothing? Why the hell did I spell it like that? I don't know. And of course, we need our pre-closing poll. The reason why I've said plus assault for everyone is if they find him guilty of anything, they'll put in the assault as well. I don't think it's going to be anything. No, jury deliberation will start after the jury instruction has been read. You know, where she'll start reading the charges and then she'll go into telling them what, if anything, is 45 pages of nothing. It's just droning on for 2 hours. Not minimizing. I've been in his position many times as a youth. I've been in a ton of fights. I've been in tons of fights where we were more, they were more. We were big bunches of people. I've been kicked, punched, strangled. Yeah. That's why I'm laughing when they're talking about all of this conscious thinking that went on in the fight, because in a fight, you don't think, you act, and then you get out of it. If this was a bigger case, I would fully respect some people to make a big deal out of how he got more serious charges for what he did than the one black kid. It's because of the severity of the damage. One kid got his arm fat sliced. The other kids had injuries that one of them has a thigh muscle that doesn't work, and the other one had drains put in. That's, yeah. feel bad for Jimmy's parents, of course, but I would like to know if it had been Jimmy on the ground being beaten by a mob, what would they want him to do? Would have, could have, should have. He's not understand. They're not understand. We don't know. Hopefully, no other parents will ever have to go through this, but sadly, they will. Probably right now, there are 10 cases going on in America where someone did something like this to someone. And that's just a sad reality because people are stupid. People think that, hey, I can pew someone and it wasn't, it's just to make a statement. And then you blow their head off. And then you're sitting there saying, but I didn't want to do it. Well, you did it. Yeah, but it was an accident. Well, tough luck. You're going away. I am in Australia and love your beautiful, comforting voice while I'm struggling with insomnia. I then rewatch. Thank you, PH, 1964. I'm happy that I can entertain. This guy made a huge mistake when he was still in high school. None of his friends stood by him. Well, they actually did because they were in the fight with him. Not even the ones that in the car. Oh, you mean after? Yeah. Well, none of them talked to each other apparently for the next 6 months, which to me is really weird because I have had quite a few friends sent upriver. And we all know what happened because most of it was for brawling in bars or pizzerias outside of bars. And we all, within 5 minutes, we know, oh, did you see that guy did that? Oh, no, but hopefully they don't have a camera there. And yeah, I don't believe everyone is talking after something like this, especially when they find out someone has passed away. Why are you telling us about your bedroom activities? Well, it's reflect because, as you know, I'm sadly single, so I'm still hoping my Russian mail order bride will come at some point, and then I'm gonna do all the things I'm talking about. We had a lot of that at these teen parties we went to where it got really crazy. And then when I got to be a few years younger, older, I started working the door because I knew a lot of the people who were making trouble, so they wouldn't fight us. And me and my buddy we're not muscular people, but we're big. And big is really effective in a fight because anyone who thinks that it's duking it out, no, it's just someone grab a shirt and then lay on top of them and say, calm down. And I stopped being a bouncer at those parties when kids, 14, 15-year-old, took their belt and took the belt buckle and stuck out the pin so they could punch you in the face with it. That's an eye you can take out with that, no problem, or you can get punched through the chin or be unlucky to get an artery. And they just didn't think. They were 14 years old. We were not allowed to just punch them, but we were told to grab them and put them on the ground till the police arrived. I couldn't because if someone came at me, that's a weapon. But that turned really crazy in the end. This still hinges on the fact for me that he very willingly placed himself on that lawn more than once, knowing what was going on. He took that knife on his way back, not at the initial fight. He had it at the initial fight. The first 3 people are sliced before he goes to the car. I thought that they said he went to the car to get it. That's what I read in the newspaper articles about it. But he apparently had it all the time and had used it before he went to the car and then came back. Him coming back and doing Jimmy McGrath in the chest to me, is he needs to go to prison for that. Because that's not just whoopsie. The flailing around when you're on the ground with people kicking you, I could see why. But my body is clear, I'm clear. That might be forming a semicircle in front of me. As long as it's not behind me, I can run. And in Connecticut, you have an obligation to run. I don't understand why he then does this, but I don't understand a lot of things. Well, we have to say certain words on YouTube because YouTube really likes to strike us with all kinds of stupid bans if we say words that are perfectly cromulent in the real world. So that's why you'll hear us say kniff and stuff like that as well, because we have to try and protect our channel a little bit, because YouTube don't like it if you say it too much, and then it's just dumb. No, he's charged as an adult because of the severity of the crime. No, he has an immunity deal. So that's the big problem. Everyone else who should be with him has immunity deals. Beat. Date. Why didn't anyone put date in yet? I just said it. Well, I'll do it. I have to do everything myself. I don't know. Your instruction is going to be boring as crap. I really don't want to cover it, but I'm going to take my lunch. Maybe I just need to take a little breather. I've been up and running around since 4 a.m. this morning, and it's 7 p.m. right now, so I might just be a little bit in a pissy mood. I should get this off. I'll be back at 2 o'clock, and we'll see how fast they can return a verdict if and when they go to the deliberation today. You understand, but it just makes no sense. That's the problem. This makes no sense because we are reasonable adults. These are teenagers, and they are people who run around, punch people, and yell for the culture. Or, yes, sir. It will never make sense to us. Well, 25 to 60 years is what he's looking at if they get him for murder, with a possibility for parole probably after 65% time served, which would mean he could be eligible for parole when he is 34 years old. I'm leaving you to it. Make sure that Sue doesn't cheat as she always do. If you're leaving, come back at 2 o'clock. If you're on Mo's channel or you're on the Rumble, you'll have to use the QR code. Then you can play along because it's in my chat. And if you're not playing along, go over on Mo's channel and give her a little love as well, because Mo is funny as all hell. I believe he's been out on a $1 million bond. $2 million bond. One or two. He's been out on bond. Yeah, house arrest. If you go away to have some lunch, which I totally understand, there's a word I don't want to type. Yeah, keep it above. We're back at 2 o'clock to have the jury instructions. If you want to get notified, follow the Discord. Really easy to find if I put it in chat. follow the Discord where we always update when we go live, or follow the Twitch chat where I try to remember to update when I go live. Love y'all. I need some manger, and 5 minutes away from being on. See you later. Find some music. What do they need today? It's so bad. I should make some holding music, but I didn't, and it's my mistake. Yes, it is. So now you have to sing. I hate this one. They're boring. Oh, 4th of July is tomorrow. That's absolutely horrible. There we go. I know how to stream. I tried it before. I haven't left. Why are you like this? Hey, Anne, how are you doing? Well, court is supposed to have started up 7 minutes ago. I gave you extra rec time today just because you weren't ready to go play in the yard. Doesn't give you more yard time. iPad's Baker is back. What? Why? Streaming so easy a Baker can do it. Yeah. It's amazing how dumb I am and I still can do it. I'm actually thinking that I might need to get a YouTube law degree just to keep streaming, because I have seen some amazing eye-opening takes that I didn't know really was a thing. And as you know, I try to always be well, not the best, because have you seen me streaming? But I'm learning so much from it's one of my big inspirations.
Yeah, I was kind of taken back by his attitude as well. I've never really heard a judge bitch and whine about something. It's a public trial, Judge. It's a public trial. I'm not saying people should bombard the judge, but the public has the right to say, hey, we don't think that this is a very fair plea deal. Could you please look at it? You're the judge and you're the last stop, right? You're the only person. Now, no, nobody should be harassing judges, but it's a public trial. And if the public wants to say, hey, can you take a look at something? They have. Yeah.
I have been misunderstanding the word public trial, because I thought that it was just you can go to the courthouse and watch the trial. But that's because I'm dumb. I'm not an A-level grifter. Public trial means that you have the law, that's X amount of the trial. Then you have the public, and the public can write in and say, hey, in our case, we don't think he should have a murder charge against him. And the judge should say, hey, I got 27 emails today saying this should only be manslaughter. So tough luck. We're gonna remove the murder charge. That's that's why I need a YouTube law degree. I know some lawyers who stream, but they don't stream YouTube law. You have people out there like Runkle of the Bailey. He's a Canadian, which always makes him better than most people. But he's a lawyer. He's not a YouTube lawyer. You have Emily D. Baker, who is a lawyer. He's not a YouTube lawyer. I think I have to go because I have never heard these people who claim that they went to law school. Have they ever told any of us that a public trial actually means that the public gets to sway the judge in a case? It's who can you trust anymore? Jemima, why haven't you told me that I actually could make a campaign? I have watched many trials where I've sat there and said, Adam Montgomery, why isn't DP a thing? Well, they don't have it in New Hampshire. Well, public trial, that is going to call for a firing squad. And the judge will just have to say, well, it's a public trial, y'all. Get those blunderbusses ready. no, Jemima, have you ever you're a lawyer, you're not a YouTube lawyer. You really need to I'm not saying that you don't understand the law, because you understand law, but you don't understand YouTube law. My new merge line that will drop tomorrow is I'm a YouTube lawyer, where you can get your diploma, and well, you can then also go on and practice YouTube law, because you just have to follow Twisted Tragedy. She has more truthings than anyone ever on the YouTubes. She is probably the smartest person I have ever listened to, and I listen to her quite a bit, because she is really, really smart. I still just spout things. So whenever I say something dumb, I go check, am I right? I was talking about the Koberger trial, saying, hey, he signed a plea deal with no appeal, so he can't appeal. But again, I was talking law, not YouTube law. So again, I go to my professor and I check what is the right answer.
That is not okay. So basically, they get this damn plea deal, right? And still have to deal with appeals. What good does that? That is not okay. So basically, they get this damn plea deal, right? And still have to deal with appeals. What good does that?
So again, I have to say, I'm so sorry to my audience that I wrongly claimed that a plea deal that has the connotation no appeals is actually not what it means. It means there will be appeals. This is why you have to forget all these lawyers and you have to start understanding YouTube law. Because in a public trial, someone can just write the judge and say, hey, I think Monday he needs a plea hearing. And the judge will have to say, I got 28 emails. We are having a plea hearing. Hey, judge, you have to deny him the plea deal, because I'm really looking forward to grifting his trial. I got 5 people to sign this petition. They can't take a plea deal. It's a public court. This is Twisted Tragedy, one of the smartest people online. Is this verdict was? No, we still haven't gotten jury instruction. She said she had to do some administrative work, but would be back at 2. And right now it's 2:15. I think I'd take a drug habit before I listen to Twisted Tragedies. This is typical you lawyers. You spent 3 years in law school. This woman has been studying law her entire life. She just didn't have time to go to law school. And you're sitting there with your diploma and saying, I'm better than you, when she clearly knows the ins and the outs of the law. So Baker, well, we will probably call it Twisted Baker, because you have to set the smart person first. Twisted Baker Law for YouTube will be enrolling our first class of students in August. Sign up. It'll be an ongoing, you will be pursuing a degree in YouTube law. It can happen whenever. You can buy your diploma in our merch store, and after that, you will have to attend our streams regularly, and there will be quizzes. One of them is, why is Jess wrong when she says that law doesn't exist? And I say it does. Because I'm a YouTube lawyer, she's a real life lawyer. It's going to be great. Yeah, but again, it's like you don't understand how she said it. I feel very insulted. Well, you shouldn't. You should just enroll for YouTube law school. As if lawyers weren't bad enough, now we have another form of them. Lawyers. Exactly. YouTube Law on a Budget this weekend. I will be guesting a British streamer this Saturday at 11 Eastern. So I'm a little hung up. Problem is, it was spelled waived, so it has no effect. Yeah, that's just how it is. You can't do anything. She's almost as smart as Doink. I wish someone would clip all of his insane stuff. It's yeah. And Jemima, you were asking about appeals, which you don't, again, law school. So I'm just going to let her tell you how this works out.
Yeah, but there are other appealable issues. That's the thing. We're not talking about just regular appeals, like, oh, you're waiving your right to appeal. Yes, usually a guilty like that comes with waiving appeals, but there are other things that they can tie up as appealable issues, even when you waive your right to waive the appeals on the case. It's like, I don't even know how to explain it. It's so complicated. He did.
Jemima, can you confirm that if you waive your right to appeal, that the Earth might be inside of a black hole resting in the eye of a turtle? Because even though I do have a degree from YouTube law, I'm not sure I quite understood how he said no to his right to appeal twice. Because 2 negatives is a positive, so he has extra rights to appeal, right? Well, you apparently don't know how to not waive an appeal, even though you waive your right to appeal. And you can waive your right to an appeal. This is Supreme Court stuff. This isn't just your rinky-dink, hey, I can go to the court and I can argue a case. We're talking, this is probably above the Supreme Court. This is stuff that, what's her name, Kwame Jackson or whatever, and Barrett or whatever their names are, they can't even touch this level. This is YouTube law. That's Supreme Court, YouTube law. Starting to sound like you got your degree in Australia. I got it online. Does the YouTube law degree come with a complimentary Twitter PhD? Well, that's actually when you go on, and I don't know if it's the master the first or the BS the first. It's when you have your law degree, you can then, but I don't know we haven't figured out what we're going to call that yet. It's not that complicated. You waive all of the appeal options. There are limited circumstances like newly discovered exculpatory evidence, but that's it. I'm feeling you're not listening to what Twisted is saying. It's almost, and I think that's your old law thinking. You are not YouTube law thinking. It's going to be the thing in the next couple of years. All of us YouTube lawyers will be practicing law in courtrooms all over the world. And if you thought that the travelers on the land had some good arguments, and yeah, of course you are not driving, you are sailing your land boat, is a great argument. Just wait till this person goes before Judge Bukowski and says, but Your Honor, he waived his right to waive his right to appeal, which means that he didn't have the right to waive the right to appeal. Therefore, he has the right to appeal. And I checked my inbox today. people have been writing he must have an appeal, and this is a public court, Your Honor. I can see this being the new soft citizen movement. No, because he has signed an agreement, he will never get the right to appeal again. You waive your right to appeal, but in Indiana, at least you cannot waive your right to pursue state post-conviction relief. Oh, I didn't know that. Yes, this is always the get out of jail free card is. You heard about this? Is she a super secret Supreme Justice? No, she's a super secret YouTube lawyer. It's way finer. BS is first. This lady is a master BSer. So law degree is a JD. So from now on, that will be known as a YJD. I take offense to that. Yeah, that's how people respond. I love that Krusty yesterday. Yeah, we're just waffling on because it ain't like anything happening. Krusty had a post about how the Diddy trial and the Can Reed trial was the same. I'm like, the only thing they have in common is you are trying to grift off of them. It's totally different charges, different states, different evidence presented, but hey, whatever floats your boat. I'm just amazed that they can sit and they have a big audience. That's the most impressive thing. I know, and I'm thankful for each and every one of you. I don't have 1,000 people watching me regularly. But when they were streaming Plevin and Caffey Daffy and them, they were having 1,500 people watching them. And I'm just thinking, you can't listen to them being this dumb if you're not dumb yourself. I make fun of stuff. I'll make a crass joke, or I'll pull up a limerick from Brandon because I am an entertainment while we're watching trial. But I do try and ask Jemima, hey, what does this mean? Or I'm trying to Google this so I can tell you, well, the law in this state states that. These people are just, I hope someone hits her with a car. That would be poetic justice. Public schooling has failed. Did you see the video Vinny posted of the crowd booing John DePetro after? No, I haven't seen that one. Again, I believe in the thing that's is a courteous in victory as in defeat. So I'll call him an idiot on Twitter, but I wouldn't boo at him. I'll just laugh at him outside. How do you find all these smart people? Well, some of them comes to me, and sadly, one of my other law professors might be stopping on Twitter, who is a non-mass lawyer, which is not Kevin Yellow Cottage Tail writing under a fake name, using ChatGPT to try and sound like he knows the law. It's not Kevin. Just so you know. The one time where he accidentally answered something that I posted to Kevin as it was Kevin was a mistake. I misunderstood it. It's not Kevin. But he is ending his run on Twitter, and people are already crying, and they needed his level-headed takes. He never ever had a level-headed take. He constantly calls Karen Reed a cop killer, which I only do YouTube law, but isn't it defamation when she is now found not guilty in killing a cop to keep calling her a cop killer? But apparently Plevin is working on his next book. I'm afraid the Koberger can still appeal. People will read acquittal can be overturned people and have babies or something. That's how idiocracy will happen. Nah, I'm the worst. As a once brilliant-minded attorney once said, as we know laws are written for us to interpret. Yeah, but they're not written so badly that I make a plea deal that I can't appeal. You can still appeal. No. I'll sign a piece of paper, no appeal. Well, this chubby chick somewhere, and I don't know, she can't sit still. It annoys my OCD to all hell. She always keeps moving around. I hope it's a drug habit, but well, at least she wasn't begging for money in those videos. Yeah, we're waiting for the judge to come back and give her the jury instructions. I'm almost dumb years old next October. How much is dumb years? Ironically, that John DiPietro hit a car, broke a tail light the day after the verdict. Yeah, and tried to walk away from it. I think we showed it during verdict watch. It wasn't Kevin, but his third twin, Ib. Yeah, the very Bostonian kid named Ib. Ib is a Danish name. He could argue it is just his opinion, I guess. Depends on how he words it. No, he puts it out there. How is it? I'm not reading it. It's in a Substack. I'm not gonna go there. What was it? One of her first calls that morning was to Jen McCabe. She had John's niece call Jen because Karen didn't have her number, but cop killer Karen Reed had first made a series of calls to Michael Camarano from around 4:46 before Jen McCabe. During her ride to the hospital the next morning, Karen told the paramedic that her last conversation with John had been an argument. How do you know this isn't what cop killer Karen Reed told Bud and it was overheard by the paramedics? The Bella's mom house comment is speculative because there is no evidence cop killer Karen Reed overheard the reference. So they used the word cop killer without any disclaimers. Oh yeah, Judge Wu. I thought it was. Jemima backed me up on this one. I asked, this must be a joke, right? And then she found out he was a real judge. He is absolutely, and it's Lou, not Wu. He's absolutely mental. I don't know if he's getting a little too old and the small gray cells doesn't work as well as they did once, but he's weird. He's effing weird. I've been trying to clip some of the stuff and make a video on him, but it's so stupid what his takes are. No worries. For what? You waited for what? Yeah, that's pretty open. It's not a alleged cop killer or wasn't found guilty of being a cop killer. Who is this moron? It's an mass lawyer, and it's not Kevin. It's not Kevin Yellow Cottage Tail. He even states it in the post because everyone is saying, bye, Kev, see you later. But it's not Kevin. It is an anonymous lawyer from Massachusetts who don't know the basic facts of the law. And every post he has written during the Karen Reed trial, he opened his account, I think, just before the second trial started. Everything is written with ChatGPT, and it's, again, I do YouTube law. I know how to spot a bullshitter. Jemima has to drive home now. Yay! From work. Thank you for leaving when everything's getting interesting.
Council, the court is prepared to charge in accordance with the jury charge that's been provided, which does reflect the changes that were discussed during the formal charging conference. The only additional change that's been made is adding some language regarding the actions of the lawyers during the trial in addition to their statements, and just some typographical errors, maybe a comma here and there, grammatical things. That's about it. But so I am prepared to move forward on this. I intend to take a break during the charge because unfortunately this charge is a rather lengthy charge. So I do want to provide the jury a few minutes to stand up and stretch. It's going to be difficult for everyone to get through just sitting. So I will give them some time to do that. We'll take a quick break in between. Additionally, I had asked about an exhibit list going in with the jury during deliberations. So I will be asking you to look at that, make sure that you agree that there's nothing on the list that inaccurately represents the exhibit as an exhibit that provides concern to you one way or the other regarding whether or not that list should go in. So you'll have additional time to do that after the court's done charging. Is there anything that the court needs to address at this time?
No, Your Honor.
Not from the defense, Your Honor.
All right, very good. So I am going to go ahead and bring the jury in then. Thank you. I just want to, well, actually, give me one moment. I'm so sorry. I just want to address everyone in the courtroom. You're welcome to be here. There are some courts that close the doors, don't allow anyone in and out of the courtroom during the judge's charge to the jury. I do not do that. However, I am going to ask for your cooperation in staying and remaining in place during the court's charge to the jury. This is a very important part of the trial. This is the law that the jury has to apply to the facts they find. If you do have to leave the courtroom, I am going to ask you to respect the court and the process enough at this point in time to not return to the courtroom during the court's charge. I will be taking a break during the charge, okay? If it's an emergency that requires you to leave and you have to come back in, that's fine, but I am going to be asking the marshals to keep an eye on that, people coming in and out, okay? So if you have to leave, that's fine. Just please be cognizant of where we are in the proceedings if, in fact, you're attempting to come back in. I want the least amount of distraction to the jurors at this time. Thank you for your cooperation. But now,
Closing arguments weren't good for any side, so don't waste your time. Just sit here and listen to her drone on for 2 hours about jury instructions.
welcome back, ladies and gentlemen of the jury. Counsel, please stipulate to each time all.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right. So once again, if you brought any notepads, I am going to ask you to set them aside. This is the jury's instructions. So I am going to instruct you on the law that is to apply to the facts you find in this case. You will have a copy of the court's jury charge with you during the deliberations. This is going to be rather lengthy, so I do intend to give you a break during the course of my charge so that you can get up, stretch, use facilities, and sort of, get comfortable and be seated again for some period of time. So you have heard the evidence presented in this case. I am now going to instruct you as to the law that you are to apply in this case. During these instructions, I will, for the most part, be reading from prepared material. I do this so that I do not inadvertently give you incorrect instructions. So if I lose eye contact with you from time to time, please bear with me. The reading of these instructions, like I said earlier, is going to take some time.
The function of the court and jury. It is exclusively the function of the court to state the rules of law that govern the case with instructions as to how you are to apply them. It is your obligation to accept the law as I stated. What I tell you, not what the attorneys tell you, is the law that you are to follow. If the law, as I give you, differs in any way from the claims of law made by counsel, dismiss from your minds what counsel have said to the extent it differs from what I tell you. You must follow all my instructions and not single out some and ignore others. They are all equally important. Also to note, in these instructions, the court does use the terms first count and count 1, second count and count 2, third count and count 3, fourth count and count 4, crimes and offenses, and information and substitute information interchangeably. You as jurors are the sole judges of the facts. It is your duty to find the facts. You are entitled in the course of evaluating the evidence to draw any and all inferences that you find reasonable and logical from the evidence you hear. You are to recollect and weigh the evidence and form your own conclusions as to what the ultimate facts are. You may not go outside the courtroom or the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or suspicion. And you must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathy. You should not be influenced by my actions during the trial and ruling on motions or objections by counsel, or in comments to counsel, or in questions to witnesses, or in setting forth the law in these instructions. You are not to take my actions as any indication of my opinion as to how you should determine the questions of fact. If I asked any questions of witnesses, you must not assume that I hold an opinion on the matter to which my questions may relate. Remember that you, as jurors, are at liberty to disregard all comments or questions of the court and the witnesses' responses to those questions in arriving at your own findings of the facts. You must not take anything I said or did during the trial as indicating what I think the evidence or what your verdict should be. Any reference I make to the evidence is only for the purpose of clarification of some point of law or a point of illustration, or to refresh your recollection as a general nature of the testimony. I do not intend to emphasize any evidence I mention or limit your consideration to it. If I do not mention certain evidence, you will use the evidence from your recollection. If my recollection of the evidence does not comport with your recollection, then it is your recollection which must prevail, because you are the exclusive trier of the facts. The defendant justly relies upon you to consider carefully his claims, to consider carefully all the evidence, and to find him not guilty if the facts and the law require such a verdict. The defendant rightfully expects fair and just treatment at your hands. At the same time, the state of Connecticut and its people look to you to render a verdict of guilt.
If you go by the normal sentencing guidelines, the 30-year would be 30 years and 65. That'll be 18. That'll be around 20 years.
Guilty if the facts and the law require such a verdict. The law prohibits the state's attorney or defense counsel from giving personal opinions as to whether the defendant is guilty or not guilty. During my instructions to you, I may repeat certain instructions. I apologize in advance. I do this for the purpose of organization. You are not to consider a repeated instruction more important than any other instruction. All instructions are equally important. Also, during my instructions, I may refer you to previous or subsequent instructions given. When I do this, I will identify it for you and direct you to the section to which I am referring. If there is an inconsistency in the number and the title of an instruction to which you are referred, it is the title of the instruction that shall be controlling in my reference to it. Presumption of innocence. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. This presumption of innocence is with the defendant when he was first presented for trial in this case. It continues with him throughout the trial unless and until such time as all evidence produced here and the orderly conduct of the case, considered in the light of these instructions of law and deliberated upon you in the jury room, satisfies you beyond a reasonable doubt that he is guilty. The presumption of innocence as to each crime charge and as to any lesser included offense as instructed by the court may be overcome only after the state introduces evidence that establishes the defendant's guilt beyond a reasonable doubt. If an
And my biggest problem is I can't raise her voice more because then all the what do you call it? All the over pitching will just blow your ear holes.
when the presumption of innocence has been overcome by evidence proving beyond a reasonable doubt that the accused is guilty of a crime charge or any applicable lesser included offense as instructed by the court, then it is the sworn duty of the jury to enforce the law and render a guilty verdict. Burden of proof. The state has the burden of proving that the defendant is guilty of the crimes with which he is charged or a lesser included offense as instructed by the court. The defendant does not have to prove his innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute a crime charge or lesser included offense as instructed. Whether the burden of proof resting upon the state is sustained depends not on the number of witnesses nor on the quantity of testimony, but on the nature and quality of the testimony. Please bear in mind that one witness's testimony is sufficient to convict if it establishes all the elements of a crime beyond a reasonable doubt. Reasonable doubt. The meaning of reasonable doubt can be arrived at by emphasizing the word reasonable. It is not a surmise, a guess, or mere conjecture. It is not a doubt raised by anyone simply for the sake of raising a doubt. It is such a doubt as in serious affairs that concern you, you would heed. That is, such a doubt as would cause reasonable men and women to hesitate to act upon it in matters of importance. It is not hesitation springing from any feelings of pity or sympathy for the accused or any other person who might be affected by your decision. It is, in other words, a real doubt, an honest doubt, a doubt that has its foundation in the evidence or lack of evidence. It is doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty. The law requires that, after hearing all the evidence, if there is something in the evidence or lack of evidence that leaves in your mind as reasonable men and women a reasonable doubt as to the guilt of the accused, then the accused must be given the benefit of that doubt and acquitted. Proof beyond a reasonable doubt is proof that precludes every reasonable hypothesis except guilt and is inconsistent with any other rational conclusion. Evidence. The evidence from which you are to decide what the facts are consists of 1. The sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. 2. The exhibits that have been received into evidence as full exhibits, including any pictures, videos, or documents that have been marked as full exhibits. 3. Any facts that the court judicially noticed. And 4. Any stipulation of the parties. In reaching your verdict, you should consider all the testimony and full exhibits admitted into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. These include 1. Arguments, statements, and questions by lawyers. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but it is not evidence. Likewise, any emotion, reenactment, or other actions displayed by counsel during this trial is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your memory of them controls. It is not proper for the attorneys to express their opinions on the ultimate issues in the case or to appeal to your emotions. Also, attorneys have a duty to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by the court's ruling on it, and you are not to hold it against any party for making objections. During the course of the trial, you may have heard counsel stand up and make comments about questions made by opposing counsel. You are not to regard any comments that counsel may have made in your deliberations. Any comments on the propriety of questions are not proper for trial, or your consideration should not be used in your deliberation. Lastly, the questions the lawyers ask of witnesses are not evidence. It is the testimony of the witnesses in response to the attorney's questions that is evidence. 2. Testimony that has been excluded or stricken. If I have excluded certain testimony, you must follow my instruction to disregard the testimony. In effect, I'm telling you to do what may be difficult, but which you will have to do your best to accomplish, and that is to accept in your minds that such stricken testimony is not evidence and must not be considered in your deliberations. 3, anything you may have seen or heard when the court was not in session. 4, anything you may have seen or heard from any spectators during the trial. 5, the document called the substitute information, which you will have with you at the time of your deliberations. The information is merely the formal manner of accusing a person of a crime to bring that person to trial. You must not consider the amended information as any evidence of the guilt of the defendant or draw any inference of guilt because he has been charged with crimes. You will note that each count in the information contains within it the alleged date and location of the offense. The state does not have to prove the exact time, date, or location of the offense beyond a reasonable doubt. However, the state must prove each element of each offense, including identification of the defendant, beyond a reasonable doubt. Direct and circumstantial evidence. There are generally two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, evidence from which you could find that another fact exists, even though it has not been proved directly. There is no legal distinction between direct and circumstantial evidence as far as probative value. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any particular evidence. Circumstantial evidence of an event is the testimony of witnesses as to the existence of certain facts or evidence or the happening of other events from which you may logically conclude that the event in question did happen. By way of example, let us assume that it is a December night and you're preparing to retire for the evening. You look out the window and you see it is snowing. You wake up the next morning, come to court, and testify that the night before it was snowing in the area of your house. That is direct evidence of the fact that it snowed the night before. You saw.
This is the statute in Connecticut. It's automatic in Connecticut law and apparently in most states.
It, and you came to court and testified to that fact. Now assume that it is.
I still think manslaughter is the most reasonable, but I can see where you come from.
Another December night, the weather is clear, there is no snow on the ground, and you retire for the evening. You wake up the next morning, you look out the window, and you see snow on the ground and footprints across your lawn. You come into court and you testify to those facts. The evidence that the night before there was no snow on the ground and the next morning there was snow on the ground and footprints across your lawn is direct evidence. That direct evidence, however, is circumstantial evidence of the fact that sometime during the night it snowed and that sometime thereafter someone walked across your lawn. The only practical difference between direct and circumstantial evidence is that when you have direct evidence of some fact, the main thing you have to do is determine the believability of the direct testimony given, the credibility of the witness. With circumstantial evidence, you must first determine the credibility of the witness or witnesses and decide whether the facts testified to did exist. Then you must decide whether the happenings of those events or the existence of those facts leads logically to the conclusion that other events occurred or other facts exist, and ultimately whether the crimes alleged were committed by the accused. There is no reason to be prejudiced against evidence simply because it is circumstantial evidence. You make decisions based on circumstantial evidence in the everyday affairs of life. There is no reason why decisions based on circumstantial evidence should not be made in the courtroom. In fact, proof by circumstantial evidence may be as conclusive as would be the testimony of witnesses speaking on the basis of their own observation. Circumstantial evidence, therefore, is offered to prove a certain fact from which you are asked to infer the existence of another fact or set of facts. Before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in light of reason, experience, and common sense. Redacted exhibits. If there are exhibits that have been accepted into evidence as redacted versions of the original, please note that these redactions were made by way of agreement by counsel or by order of the court, and you must not speculate as to why the information was redacted or what was redacted. Redacted information is not evidence, and as indicated earlier, you may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or speculation. Credibility. In deciding what the facts are, you must consider all the evidence. In doing this, you must decide which testimony to believe and which testimony not to believe. You may believe all, none, or any part of any witness's testimony. In making
I
that decision,
choose
you may consider a
50%.
number of factors, including the following. 1. Was the witness able to see or hear or know the things about which that witness testified? 2. How well was the witness able to recall and describe those things? 3. What was the witness's manner while testifying? 4. Did the witness have an interest in the outcome of this case or any bias or prejudice concerning any party or any matter involved in the case? 5. How reasonable was the witness's testimony considered in light of all the evidence in this case? And 6. Was the witness's testimony contradicted by what that witness has said or done at another time, or by the testimony of other witnesses, or by other evidence? If you think that a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely upon any of that witness's testimony. In deciding whether to believe a witness, keep in mind that people sometimes forget things. You need to consider, therefore, whether a contradiction is an innocent lapse of memory or an intentional falsehood. And that may depend on whether that contradiction has to do with an important fact or with only a small detail. These are some of the factors you may consider in deciding whether to believe testimony. The weight of the evidence presented does not depend on the number of witnesses. It is the quality of the evidence, not the quantity of the evidence, that you must consider. Witness with a cooperation agreement. You have heard evidence that witnesses Jack Snyder and Tyler De Silva have signed a document entitled Cooperation Agreement with the state, terms of which are contained in States Exhibit 94 and 96, respectively. These agreements are permissible, and the rules of court provide for their use. Although the state is permitted to present the testimony of someone who has signed a cooperation agreement in exchange for his testimony, you must examine the testimony of such a witness who provides evidence against the defendant with greater care and caution than the testimony of an ordinary witness. While examining the testimony of a witness who has signed a cooperation agreement and who has not been prosecuted with offenses for which the state has evidence, you should keep in mind that he may, in his own mind, be looking or hoping for some favorable treatment in the disposition of his own matters, and therefore may have such an interest in the outcome of this case that his testimony may have been colored by that fact. In considering the testimony of such a witness, you may consider whether there was any motive developed in the evidence for testifying falsely in inculpating the accused. The factors you may consider, among others, when evaluating the credibility of such a witness include the extent to which the witness's testimony is confirmed by other evidence, the specificity of the testimony, the extent to which the testimony contains details known only by the perpetrator of the alleged offense, the extent to which the details of the testimony could be obtained from a source other than the defendant, the circumstances under which the witness initially provided information supporting such testimony to law enforcement or a prosecutorial official, whether the witness has received a benefit or expects to receive a benefit, including immunity from prosecution, leniency in prosecution, leniency in sentencing, or personal advantage in exchange for testimony, and whether the witness has ever changed his testimony. Further, notwithstanding any language contained in Exhibits 94 and 96, the cooperation agreement signed by Jack Snyder and Tyler De Silva, respectively, it is your exclusive role to determine the credibility and believability of that witness. In other words, you and you alone are to determine whether any evidence offered by Jack Snyder or Tyler De Silva is to be believed wholly, partly, or not at all, irrespective of any language in the cooperation agreement that may suggest otherwise. The determination as to whether the state has proven the elements of the crimes charged beyond a reasonable doubt rests solely with the jury after a careful examination of all the evidence presented. You should carefully scrutinize the testimony of Jack Snyder and Tyler De Silva before you accept it. However, you are not required to disbelieve a witness because he has signed a cooperation agreement. The law recognizes that there are many offenses that are of such character that the only persons capable of giving useful testimony are those who are themselves implicated in the crime. Like all other questions of credibility, this is a question for you to determine based on all the evidence presented to you. It is your duty to decide what credibility to give to any witness. Therefore, it is your duty to decide whether Jack Snyder and Tyler De Silva are to be believed fully, partly, or not at all. Testimony of police officials. Police officials have testified in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall the police official's demeanor on the stand and manner of testifying and weigh and balance just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official just because he or she is a police official. Expert testimony. In this case, certain witnesses have taken the stand, given their qualifications, and testified as expert witnesses. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which the testimony relates. An expert is permitted not only to testify to facts that he or she personally observed, but also to state an opinion about certain circumstances. This is allowed because an expert from experience, research, and study generally has a particular knowledge of the subject of the inquiry and is more capable than a layperson of drawing conclusions from facts and basing an opinion on them. An expert witness may state an opinion in response to a hypothetical question. A hypothetical question is one in which the witness is asked to assume that certain facts are true and to give an opinion based on those assumptions. The value of the opinion given by an expert in response to a hypothetical question depends upon the relevance, validity, and completeness of the facts he or she was asked to assume. The weight that you give to the opinion of an expert will depend on whether you find the facts assumed or proved, and whether the facts relied on in reaching the opinion were complete, or whether material facts were omitted or not considered. Like all other evidence, an expert's answer to a hypothetical question may be accepted or rejected in whole or in part according to your best judgment. In this case, you were provided expert testimony by the following witnesses: Dr. James Gill, Dr. Ryan Doss, PA Eric Black, and Dr. Roselle Crombie. Allowing someone to give expert testimony is in no way an endorsement by the court of the testimony or the credentials of the witness. Such testimony is presented to you to assist you in your deliberations. No such testimony is binding upon you, and you may disregard the testimony, either in whole or in part. It is for you to consider the testimony with the other circumstances in the case and, using your best judgment, determine whether you will give any weight to it. And
She's been reading it well, but again, it's just this droning on. It's so unnecessary to sit and read it all because they have to go back and reread it. None of them can hear what she says anymore. They have fallen asleep.
So, what weight you will give to it. The testimony is entitled to such weight as you find the expert's qualifications in his or her field entitle it to receive, and it must be considered by you, but it is not controlling upon your judgment. You are also to consider his or her general credibility in accordance with the instruction on credibility applicable to all witnesses. Defendant's testimony. In this case, the defendant testified. An accused person having testified stands before you just like any other witness. He is entitled to the same considerations and must have his testimony tested and measured by you by the same factors and standards as you would judge the testimony of any other witness. You have no right to disregard the defendant's testimony or to disbelieve the defendant's testimony merely because he is accused of committing multiple crimes. Consider my earlier instruction on the general subject matter of credibility and apply them to the defendant's testimony. Proximate cause. Proximate cause does not necessarily mean the last act or cause or the act and point in time nearest to the death or injuries. The concept of proximate cause incorporates the principle that an accused may be charged with a criminal offense even though his acts were not the immediate cause of the death or injuries. An act or omission to act is a proximate cause of the death or injuries when it substantially and materially contributes in a natural and continuous sequence, unbroken by an efficient intervening cause to the death or injuries. It is a cause without which the death or injuries would not have occurred. It is a predominating cause, a substantial factor from which the death or injuries follow as a natural, direct, and immediate consequence. It does not matter whether the particular kind of harm that results from the defendant's act be intended by the defendant. When the result is a foreseeable and natural result of the defendant's conduct, the law considers the chain of legal causation unbroken and holds the defendant criminally responsible. Specific intent. Specific intent is the intent to achieve a specific result. A person acts intentionally with respect to a result when his conscious objective is to cause such result. What the defendant intended is a question of fact for you to determine. The concept of specific intent applies to count 1, murder and manslaughter in the first degree intentional as a lesser included offense. Count 2, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense. Count 3, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense. And count 4, assault in the second degree intentional. Recklessness. A person acts recklessly with respect to a result or to a circumstance described by a statute defining an offense when the defendant is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstance exists. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. The standard of conduct of a reasonable person in the same situation as the defendant is the doing of something that a reasonably prudent person would do under the circumstances, or omitting to do what a reasonably prudent person would not do under the circumstances. A gross deviation is a greater substantial deviation, not just a slight or moderate deviation. There must be a great or substantial difference between, on the one hand, the defendant's conduct in disregarding a substantial and unjustifiable risk, and on the other hand, what a reasonable person would have done under the circumstances. Whether a risk is substantial and unjustifiable is a question of fact for you to determine under all the circumstances. The concept of recklessness applies to count 1, manslaughter in the first degree, reckless as a lesser included offense. Count 2, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. Count 3, assault in the reckless degree, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. And count 4, assault in the second degree, reckless as a lesser included offense. Evidence of intent. What a person's intention was is usually a matter to be determined by inference. No person can testify that he or she looked into another's mind and saw therein a certain knowledge or a certain purpose or intention to do harm to another. Because direct evidence of a defendant's state of mind is rarely available, intent is generally proved by circumstantial evidence. We will refer to the court's earlier instruction on direct and circumstantial evidence. The only way a jury can ordinarily determine what a person's intention was at any given time is by determining what the person's conduct was and what the circumstances were surrounding that conduct, and from that infer what his or her intention was. To draw such an inference is the proper function of a jury, provided, of course, that the inference drawn complies with the standards for inferences as explained in connection with my instruction on circumstantial evidence. The inference is not a necessary one. You are not required to infer a particular intent from the defendant's conduct or statements, but it is an inference that you may draw if you find that it is reasonable and logical. I remind you again, the burden of proving intent beyond a reasonable doubt is on the state. Evidence of motive, or the lack of it, may also be considered by you in determining the issue of intent. You will refer to the court's instruction on motive below. Motive. The law does not require that the state in a criminal case prove a motive because it is not an element of a crime. It is not necessary for the state to prove what reason the defendant may have had for committing a crime charged. Because crimes are generally committed for some motive, evidence of a motive may tend to prove the guilt of a defendant. In the same manner, if there appears no adequate motive on the part of the defendant to commit the crime, that may tend to raise a reasonable doubt as to the guilt of the defendant. If the existence of a motive can be reasonably inferred, that may tend to prove the defendant's guilt. If no motive can be inferred, it may or may not raise a reasonable doubt as to the guilt of the defendant. If the absence of a motive does not raise a reasonable doubt that the defendant is guilty, then the fact that the state has not proved what the defendant's motive was does not prevent you from returning a verdict of guilty. Consciousness of guilt. In any criminal trial, it is permissible for the state to show that conduct or statements made by a defendant after the time of the alleged offense may have been influenced by the criminal act. That is, the conduct or statements show a consciousness of guilt. For example, flight when unexplained may indicate consciousness of guilt if the facts and circumstances support it. Such acts, however, do not raise a presumption of guilt. If you find the evidence proved and also find that the acts were influenced by the criminal act and not by any other reason, you may but are not required to infer from this evidence that the defendant was acting from a guilty conscience. The state claims that the following conduct is evidence of consciousness of guilt: the defendant's disposing of the knife, the defendant's denial of his involvement in text messages to his girlfriend, and the defendant's flight from the jurisdiction of Florida. It is up to you as judges of the facts to decide whether the defendant's acts, if proved, reflect a consciousness of guilt, and to consider such in your deliberations in conformity with these instructions. Identification of the defendant. The state has the burden to not only prove every element of a crime, but also the identity of the defendant as the perpetrator of the crime. You must be satisfied beyond a reasonable doubt of the identity of the defendant as the one who committed the crime, or you must find the defendant not guilty. If you have a reasonable doubt as to the accuracy of the identification, you must find the defendant not guilty. Specific charges brought by the state. I will now turn to the specific offenses charged in this case. The substitute information in this case contains 4 counts against the defendant. In other words, the state charges the defendant with committing 4 separate offenses or crimes. You are to consider only the specific charges submitted to you and not concern yourself with how the information may have read when it was read to you at the start of trial. Please note, you will also be instructed to consider lesser included offenses where applicable. Additional instructions on your consideration of lesser included offenses will be provided further along in this charge as it concerns your deliberations on each count. The defendant is entitled to and must be given by you a separate and independent determination of whether he is guilty or not guilty as to each crime charged in each count, including lesser included offenses, if applicable, as instructed in accordance with this charge. Each of the 4 counts charged in the information, including lesser included offenses where applicable, sets forth a separate and distinct crime. The state is required to prove each element of each crime charged in a count, including lesser included offenses, beyond a reasonable doubt. Each crime charged under each count, including lesser included offenses where applicable, must be deliberated upon separately. Please note, the total number of counts charged in the information does not add to the strength of the state's case. You may find that some evidence applies to more than one count in the information or more than one crime under a count. The evidence, however, must be considered separately as to each element of each crime deliberated upon. Each count is a separate entity. You must consider each count separately, including lesser included offenses as instructed, and return a verdict, a separate verdict for each count. This means that you may reach opposite verdicts on the 4 different counts. A decision on one count does not bind your decision on any other count. I have previously instructed you and herein reiterate The substitute information is not evidence, it's merely a paper statement of the charges against the defendant, on which the state proceeds to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt of the defendant from the substitute information. You will first deliberate on count 1, and then follow the order of deliberations as provided by the court in these instructions. So you're going to proceed to the court's instruction on count 1, murder. Statutory title, which is immediately below. 1, count 1, murder, Connecticut General Statutes, section 53A, 54A, subsection A. The state charges the defendant in count 1 with murder, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Valle with intent to cause the death of one James McGrath, did stab and cause the death of the said James McGrath in violation of section 53A-54A, subsection A, the Connecticut General Statutes. The statute defining the offense of murder reads in pertinent part as follows. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person. For you to find the defendant guilty of this charge, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, intent to cause. The first element is that the defendant specifically intended to cause the death of James McGrath. There is no particular length of time necessary for the defendant to have formed the specific intent to kill James McGrath. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Murder is a specific intent crime, and you will refer to the court's earlier instruction on specific intent. The intent to cause death may be inferred from circumstantial evidence. You will refer to the court's earlier instruction on direct and circumstantial evidence. The type and number of wounds inflicted as well as the instrument used may be considered as evidence of the perpetrator's intent, and from such evidence an inference may be drawn that there was an intent to cause death. Any inference that may be drawn from the nature of the instrumentality used and the manner of its use is an inference of fact to be drawn by you upon consideration of these and other circumstances in the case in accordance with my previous instructions. Such inferences are not necessary, but they are inferences you may draw if you find they are reasonable and logical and in accordance with my instructions on circumstantial evidence. Declarations and conduct of the accused before or after the infliction of wounds may be considered if you find they tend to show the defendant's intent. This inference is not a necessary one, that is, you are not required to infer intent from the defendant's alleged conduct, but it is an inference you may draw if you find it reasonable and logical and in accordance with my instructions on circumstantial evidence. Element 2, cause of death. Second element is that the defendant acting with the intent to cause the death of James McGrath caused the death of James McGrath. This means that the defendant's conduct was the proximate cause of James McGrath's death. I'm going to refer to the court's earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, for the crime of murder, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause the death of James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the offense of murder, you shall find the defendant not guilty of the crime of murder and shall then next move on to consider lesser included offenses to murder below in the manner and order therein instructed therein. Proceed to the court's instruction on lesser included offenses to murder below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of murder, you shall next consider the defendant's claims of self-defense and defense of others. You'll refer to the court's instruction on self-defense and defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved beyond a reasonable doubt
because he didn't lay the foundation for self-defense when he was cross-examining the witnesses. He he was actually going with "I didn't do it" defense, and that's not what his client said when he was on the stand. And he had a way, kind of like Lally, just asking and asking and asking the same question over and over. That's why I'm annoyed with him.
One of the statutory disqualifications, you shall reject the defenses and find the defendant guilty of murder in violation of Connecticut General Statute, Section 53A-54A, subsection A at count 1. Please note, the state in proving statutory disqualifications has to prove the statutory disqualifications also beyond a reasonable doubt. This will end your deliberations on count 1. You will not deliberate lesser included offenses to murder. You will now deliberate on count 2. We'll skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault with first degree intentional below. If, however, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, but on the strength of the defenses alone, you must find the defendant not guilty of murder at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations on count 1. You will now deliberate on lesser included offenses to murder. You will now deliberate on count 2. You will skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault with first degree intentional below. Lesser included offenses to murder. In accordance with the court's previous instructions, you will consider lesser included offenses to murder under this section if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of murder and therefore have found the defendant not guilty of murder. The defendant at count 1, the substitute information is specifically charged with the crime of murder. The offense of murder under our penal code is such that it may include the elements of the crimes of manslaughter in the first degree intentional and manslaughter in the first degree reckless. This brings into play the rule of law known as lesser included.
Well, you have a lot to work with. You have every witness who was attacking him. You have to make them more aggressive than came out. You have to say, well, they couldn't get away. You were putting them on the ground. Because what he just asked was, well, you just wanted a fight, right? You wanted a fight, but it's okay to want a fight. That doesn't make it an excuse to bring a knife into it. And that's my problem is you can lay foundation that you're going for self-defense by saying, but when you were stomping him in the head, could he get away? How many were you on him? So you could instill that I was afraid in them. And you should have prepped your own witness way better because he didn't say all the magic words that he needed to say. And I think if he gets murder, most of it is because he had such a bad performance on cross-examination. Because one thing is to prep him for direct, but you need to prep him for cross-examination.
Offenses. You will consider lesser included offenses to murder in the order and under the circumstances set forth herein. The fact that I am instructing you on lesser included offenses should not be interpreted by you that I believe the evidence proved the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case, and you must determine whether the defendant is guilty beyond a reasonable doubt of murder at count 1 or is guilty of any respective lesser included offense. You will first consider the lesser included offense of man.
Then you instruct your client, you must take a plea deal, and then you just do I can't put you on the stand because you are so horrible. That's also something a defense lawyer should tell his client, because he can have, by putting him on the stand, he can have brought the 40-year plea deal to a 60-year in prison instead.
Slaughter in the first degree, intentional. Connecticut General Statute, Section 53A, 55A1, directly below, at subsection A. We proceed to the court's instruction. Subsection A, manslaughter in the first degree, intentional. The statutory reference directly below. Subsection A, manslaughter in the first degree, intentional. Connecticut General Statutes, Section 53A, 55A1. Statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when, with intent to cause serious physical injury to another person, he causes the death of such person. For the defendant to be found guilty of this charge, the state must prove the following two elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. First element is that the defendant specifically intended to cause serious physical.
Ineffective counsel. He needs to be on drugs, sleeping outside of the courthouse, not remembering his own name, and thinking that he's there defending a unicorn. The bar is so immensely high that it'll never happen. We have had defense attorneys say, please don't be too mean to my client, and sit down again. That's still effective counsel. He showed up. He had his meetings with his clients. That's nothing. I don't think we will ever see ineffective counsel anywhere.
Physical injury to another person. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury, which creates.
It's never the family who decides anything. It's the state's attorney. If he doesn't have enough, he has to tell the family. Just like in the Koberger said, we guarantee you peace right now. Two of the families are saying, well, we want him dead. He's not going to be dead anyway. And we're not going to waste 20 years on appeals. It's the sole decision. I know that Twisted said it's a public court, so the public can weigh in, but they can listen. But in the end, it's the state's attorney who says, this is what's going to happen.
Creates substantial risk of death, or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. You will note that the basis of the charge under this statute is not that the defendant intended to kill, but that he intended to inflict serious physical injury. A person acts intentionally with respect to a result when its conscious objective is to cause such result. Refer to the court's earlier instruction on specific intent at 15. The intent to cause serious physical injury may be inferred from circumstantial evidence. Refer to the court's earlier instruction on evidence of intent at 17. Element 2, cause death. The second element is that the defendant, acting with the intent to cause serious physical injury to a person, caused the death of a person.
Oh, that way.
This means
Okay.
that the defendant's conduct was the proximate cause of the decedent's death.
That was the other way around.
Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause serious physical injury to James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, you shall find the defendant not guilty of manslaughter in the first degree intentional at count 1, and you shall next consider the lesser included offense of manslaughter in the first degree reckless. Proceed to the court's instruction B, manslaughter in the first degree reckless, Connecticut General Statutes, Section 53A, 55A3 below. If, however, you unanimously find the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree intentional, you shall not consider any additional lesser included offense. You shall, however, consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of manslaughter in the first degree, intentional, in violation of Connecticut General Statute, Section 53A, 55A1 at count 1. This will end your deliberations at count 1. You will next deliberate on count 2. Proceed to the court's instruction. Count 2, assault in the first degree intentional, Connecticut General Statutes, 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree intentional in violation of Connecticut General Statutes 53A, 55A1 at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 1. You will not consider any additional lesser included offenses to murder. You shall skip over the court's instructions at subsection B below and next deliberate on count 2. B, manslaughter in the first degree reckless, Connecticut General Statutes 53A, 55A3. You will deliberate on this lesser included offense to murder if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of murder, and therefore you have found the defendant not guilty of murder. And further, you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, and therefore you have found the defendant not guilty of manslaughter in the first degree intentional. The statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a grave risk of death to another person and thereby causes the death of another person. For the defendant to be found guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a grave risk of death. The first element is that the defendant engaged in conduct that created a grave risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant's conduct demonstrated an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, cause of death. The fourth element is that the defendant's conduct caused the death of James McGrath. This means that the defendant's conduct was a proximate cause of the decedent's death. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a grave risk of death. 2, the defendant acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree reckless, you shall find the defendant not guilty of manslaughter in the first degree reckless to count 1. Send your deliberations at count 1. You shall next move on to deliberate on count 2. And proceed to the court's instruction on count 2, assault, first degree intentional, Connecticut General Statute 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A, 55A3 at count 1. This will end your deliberations at count 1. You shall move on to deliberate on count 2. Proceed to the court's instruction on count 2, assault, first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, after considering the defenses, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree reckless at count one, even
Not
though
even an
you have
hour
found the elements of
just
that
feels
crime
like forever.
proven beyond a reasonable doubt. This will enter deliberations at count one. You shall move on to deliberate on count two. You'll proceed to my instruction on count two, assault in the first degree intentional, Connecticut General Statute, section 53A-59A1 below. All right. I'm going to give you a few minutes to stand up and stretch.
Thank you. I think we need this.
I'm Jimmy. How y'all doing?
You know what we do?
Yes.
When did you first meet Maureen?
This is the summer of 14.
And where did you meet her?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has. Everybody has.
Oh my gosh, you guys! There's a class called Basic Grifting. Should we all learn how to be grifters together?
We needed that. That was count one. That was 1 hour. Count 2 and 3 is aggravated assault, and count 4 is assault, I think. Where did the term pregnant pause originate? That originated in the case against the young girl who pew-pewed her mom and tried to pew-pew her dad. I can't remember her name, but the judge was so mad at both the prosecution and the defense because they kept effing up all the time. They were late. They kept arguing. They didn't turn over evidence. It was a wonderful case. My post-it note system is when anyone like Atheist and sends me a super chat, I'll make a post-it note of it and put it up on the boards to remind me how lucky I am that I have people who support this little stupid journey of my YouTubing. So I have the different board for the different types of super chats you can have. And as you can see, my doors, I'm looking very, very German right now. That's not a good look. I have my door right there. So every time I walk in, I am reminded to be appreciative of all the wonderful people who makes it possible for me to do what I like, and then sometimes do a little bit extra, like go to the States or buy some.
Court stop back in session. The honorable person now presiding.
That's what I'm doing.
Your Honor.
Are you may be seated? Thank you.
Back in session.
Yeah, Carly Gregg. Carly Gregg. Yeah, it's a nice way to remind myself that I am blessed. Oh, a pregnant pause. It's just a pause where you think about what you're doing wrong. I don't know why he uses that term, but it's a correct phrase, but no one uses it anymore. It just means take some time to really think about how this is going. And I love that judge. Him and Judge Borowski are my two favorite judges. He was an Austrian, yes. But I've had my cap on all day, so got a little flat hair. Yeah, I would just wished I was more than 2 inches.
Your Honor, just one.
Yeah, we'll wait on. Thank you.
I'll set Your Honor.
Thank you. Okay. All right, welcome back, ladies and gentlemen of the jury. I want to thank you for your patience during the reading of these instructions. I know that it's a long time to be seated, so thank you for your attention. Counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right, thank you so much. I'm going to continue. So I'll be continuing with count 2. Assault in the first degree intentional, Connecticut General Statutes 53A, 59A1. State charges the defendant at count 2 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant with intent to cause serious physical injury to one Ryan Hines did cause serious physical injury to the said Ryan Hines with a dangerous instrument, to wit, a knife, in violation of section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when, with intent to cause serious physical injury to another person, he causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. The first element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. We refer to the court's earlier instruction on specific intent. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by a statute as physical injury which creates a substantial risk of death.
Is Danish and German a similar language? Well, we learn it from a very young age, so we're used to it. They have a weird way of like grammar and stuff like that, and they put words together in a different way than we do it. But we are more like the British because, hey, we used to rule the British Isles when we were over there beating up the pre-French British, and then the Danish people who lived in France came over and beat us. So again, everywhere is Danish. So a lot of the same words kind of goes back and forth between Danish and English, but German has a different structure, but it's super easy to learn if you speak Danish. But so is English. So I think actually some people claim that Danish is one of the worst languages to learn. I think Finnish, Icelandic, and Hungarian are the worst, and then Danish is in top 10 or something.
Or which causes serious disfigurement, serious impairment of health, or serious loss of impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Ryan Hines. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's earlier instruction on proximate cause. We must find it proved beyond a reasonable doubt that Ryan Hines was seriously injured as a result of the actions of the defendant. It does not matter whether Ryan Hines was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person, and that he in fact caused serious physical injury to that person or some other person. Element 3, with a dangerous instrument. Third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it was used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had that potential under the circumstance. In summary, the state must prove beyond a reasonable doubt that, one, the defendant had the specific intent to cause serious physical injury to another person, the defendant did cause serious physical injury to Ryan Hines, and three, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in the first degree intentional at count 2, and shall move on to consider lesser included offenses to assault in the first degree intentional below, in the manner and order prescribed therein. You will proceed to the court's instruction on lesser included offenses to assault in the first degree intentional under the section below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, you shall next consider the defendant's claims of self-defense, defense of others. Refer to my instruction on self-defense, defense of others below at 23. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not
You said
act in
this
self-defense or in
1,000
defense of
times.
others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, then you shall reject the defenses and find the defendant guilty of assault in first degree intentional in violation of Connecticut General Statutes 53A, 59A1 at count 2. This will end your deliberations at count 2. You will not consider lesser included offenses. You will move on to deliberate count 3. So you'll skip over lesser included offenses to assault in the first degree intentional below and proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defense alone, you shall find the defendant not guilty of assault in the first degree intentional at count 2. Even though you have found the elements of the crime of assault in the first degree intentional proved beyond a reasonable doubt. This will end your deliberations as to count 2. You shall then move on to deliberate count 3. You will skip the court's instruction on lesser included offenses to assault in the first degree intentional below and proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 2 if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore have found the defendant not guilty of assault in the first degree intentional at count 2. The defendant at count 2 of the information is specifically charged with the crime of assault in the first degree intentional. The offense of assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree, both intentional and reckless. This brings into play a rule of law known as lesser included offenses at count 2 as applicable to the crime of assault in the first degree intentional. You will consider lesser included offenses as to count 2 in the order and under the circumstances instructed herein. The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 2 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offenses. You, the jury, are the sole judges of the facts of this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below. Proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 directly below. A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person and thereby causes serious physical injury to another person. For you to find the defendant guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result of circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. They refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused serious physical injury. The fourth element is that the defendant caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain.
Don't you do
It is
that,
more than a
Vicky
minor or superficial injury. It is defined by statute as physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death, 2, he acted recklessly, 3, he acted under circumstances evincing an extreme indifference to human life, and 4, he caused serious physical injury to Ryan Hines. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 2, and you shall then consider the lesser included offense of assault in the second degree intentional. You'll proceed to the court's instruction on B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree reckless.
Of course, Jesus spoke English. Why is the King James Bible written in English if he didn't speak English? That's just something everyone knows.
In violation of Connecticut General Statutes 53A, 59A3 at count 2. This will end your deliberations at count 2. You shall not consider any other lesser included offense at count 2. You will skip the court's instructions in subsections B and C below and shall next move on to deliberate on count 3. We'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, that on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall not consider any other lesser included defenses at count 2, included offenses at count 2. You will skip the court's instructions at subsections B and C below. You will move on to deliberate on count 3.
She's going to send them home, right? After jury instructions. It's going to be a waste of 3 hours of reading because it's 4 o'clock now. Or do she, the one in chat, if you think that she's going to let them go back and deliberate because she thinks it's a quick verdict, or 2, if she sends them home and they come back Monday.
Each the court's instruction on count 3 assault, first degree intentional.
No, tomorrow is when America celebrates that they were good at hide and seek in 1776.
Connecticut General Statutes 53A, 59A1 below. Still under lesser included offenses, B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore have found the defendant not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 2. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of a discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove beyond a reasonable doubt 3 elements. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. You will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Element 2, cause physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injury.
Yeah, I think it's stupid to read because then they'll have to come back and spend 2 hours reading it Monday morning.
Defendant. You will refer to the court's previous instruction on proximate cause at 14. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury.
I don't think we got the reason.
If you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or to some other person. Element 3, the dangerous instrument. Third element is that the defendant caused the injury by means of a dangerous instrument other than by means of a discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury.
I won't have that anti-Danish talk. No one was trying to speak Welsh. As I just said, Denmark beat the British. We occupied a big tract of land over there. They had a lucky little uprising. They might have pushed us out. Then you had the Normans. Normans are from Normandy in France. Though they were Vikings who thought, instead of just beating the English, we've done that so much, let's go beat up the French. So the French, because the French are smart, said, hey, monsieur, let us hire you so you can live here, protect us from the other Vikings. And then the Normans are actually Vikings. In 1066, they got so bored being stuck in France because in France they eat snails and frog legs and drink wine. So they wanted to go back to Britain. So after the Danish had softened up the British army, we had some supply issues, so we didn't beat them that day. But then the reserve Danish from the French coast came in, and William the Bastard took over the country and became William the Conqueror. So thank you, Britain. Without the Danish, you wouldn't be there. You would still be sheepshackers from Wales. That's history. You can't change the fact. Denmark is the bestest country in the world. And tomorrow, when you are having your fireworks, remember, if we didn't start Britain, no one had started America. You're welcome.
Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you
I forgot our local Welsh representation. At least I didn't call you Irish.
unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of assault in the second degree intentional at count 2, and you shall then consider the lesser included offense of assault serious loss and impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use,
I didn't say you were from the Falkland Islands.
physical injury or death. The state
I
need
don't
not
have
prove that in
anyone
fact death or serious
watching from
physical
the
injury
Falklands.
resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1,
Well, by the way, Scarlett Johansson is named Johansson because her last name is from her Danish father. So all men in chat, you're welcome.
the defendant acted recklessly, 2, the defendant caused serious physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument.
No, it's because she has to read the charts, then she has to read the lesser included in all of the charges, and if they find him guilty, then they will have to see if it's self-defense or it's self-defense of others. For those of you who like the Walking trilogy, without the Danes, no Viggo Mortensen, so Arrogant wouldn't have been in that movie. You're welcome.
Unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless. You shall find the defendant not guilty of assault in the second degree reckless at count 2. This will end your deliberations at count 2. You shall next move on to deliberate on count 3. Proceed to the court's instruction. Count 3, assault in the first degree intentional. Connecticut General Statute, section 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, then you shall next consider the
He was quite busty.
self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond
do
a
it on a
reasonable
whim.
doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statute, section
Expert always talks about them. I don't know any Danish people who eat those. It was something that you might have seen at your grandma's house when you were a kid, and she bought it in Germany by mistake. It's the driest, most boring cookies you can have in the world.
53A 68.3 at count 2. This will end your deliberations on count 2, and you shall move on to deliberate on count 3. You'll proceed to the court's instruction in count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A, 1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will enter deliberations at count 2. You shall move on to deliberate at count 3. Proceed to the court's instructions. Count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A, 1 below.
Yeah, if you go by the song Jerusalem, then when he arose from the tomb, he was running around on the green hills of Britain for a couple of days. So he, of course, he spoke English.
Count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A, 1. The state charges the defendant in count 3 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause serious physical injury to one Thomas Connery Jr., did cause serious physical injury to the said Thomas Connery Jr. with a dangerous instrument, to wit a knife, in violation of section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when with intent to cause serious physical injury to another person. He causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of this
My
charge,
town
the
is
state
more than
must prove the
600
following
years
three
older.
elements
No,
beyond a reasonable
500 years
doubt.
older than that.
Element 1, intent to cause serious physical injury. First element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Refer to my earlier instruction on specific intent at 15. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Thomas Connery Jr. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was seriously injured as a result of the actions of the defendant. It does not matter whether Thomas Connery Jr. was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person and that he in fact caused serious physical injury to that person or to some other person. And element 3, with a dangerous weapon or instrument. The third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it was used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article is capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument. If under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death, the state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person. 2, the defendant did cause serious physical injury to another person. 2, the defendant did cause serious physical injury to Thomas Connery Jr. I'm sorry. I'm going to strike the in summary that I just gave. Let me just read through that again. In summary, the state must prove beyond a reasonable doubt that one, the defendant had the specific intent to cause serious physical injury to another person. Two, the defendant did cause serious physical injury to Thomas Connery Jr. And three, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in the first degree intentional at count 3. And you shall next consider the lesser included offenses, starting with assault in the first degree reckless, proceed to the court's instruction on lesser included offenses to assault in the first degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree intentional in violation of Connecticut General Statutes 53A-59A1 at count 3. This will enter deliberations at count 3. You will not consider lesser included offenses. You will move on to deliberate on count 4. Skip the court's instruction below on lesser included offenses to assault in the first degree intentional and proceed directly to the court's instructions on count 4, assault in the second degree intentional, Connecticut General Statutes 53A-68-2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you shall find the defendant not guilty of assault in the first degree intentional at count 3, even though you have found the elements of the crime of assault in the first degree intentional proved beyond a reasonable doubt. This will end your deliberations as to count 3. You will not consider lesser included offenses. You shall move on to
Ginger,
deliberate on
we are
count
having
4.
all the fun.
Skip the court's
We are
instruction
discussing
below on
which
lesser included
cakes and you
offenses
need
to
to
assault in the first degree
store your
intentional,
buttons
and
in.
proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A-68-2 below.
Oh, I forgot a page.
I am going to give you another 5 minutes just to stand up, take a break, and take a 5-minute recess because I know this is long, okay? Or it's going to stand in recess for 5 minutes again.
So I put up a poll earlier. What do you think? Manslaughter plus assault wins with 37%. That's where I am too. Involuntary manslaughter with assault 32%. Not guilty 16%. Red rum plus assault 14%. I think, yeah, that's probably, if we look at how the chat has been deliberating over the last 10 days, I think that's probably a good summation of where we are. But that's a hung jury. But oh, I feel sorry for you. You couldn't make a real cake. You need had to make a cheesecake. But for any of you who might not know what we are talking about when we're talking about the tin, these are the driest, most boring cookies you can ever have. No one in Denmark has it, eats them. Your grandma might have had them back then. The only potentially edible one is the kringel, because that has pearl sugar, as we call it, on it. The rest is just dry vanilla, and all of them taste of the same. So, but the tin is, every household at least back in the day, had one of these. Moms would have them for your sewing stuff. You would stack them so you had something when you needed a tin out in the kitchen. Sadly, we threw out a lot when my mom passed away. So I have to go out and buy tins to store my cakes in. So, but that's a staple that everyone thinks that Danish people eat, and they are too dry and too boring. Yeah, that's what everyone did. I hate those cookies except the one with sugar. Yeah, it's just dry. Dutch windmill cookies are the driest. I think the little biscotti you get with a coffee in Italy is probably the driest cookie in the world, because it's as dry as the old tack they ate on ships back in the sail age. Well, it's just I thought that you had an accident since you were making a cheesecake. No, they're not. They're boring. The square one has slight coconut flavor. That's in this. You can't discern that. I never found cookies in the tin. No, there's always needles or pins or buttons or some yarn. Well, a senke in Denmark is a pound cake because it's a true cake. That's what it stands for. Because it's the same amount of flour, sugar, and butter. They're dry. Dutch stroopwafel is excellent. Well, it's a sweet cracker, so that's a cookie. Oh, if you can get the butter cookie with the milk chocolate on the bottom, those are the good ones.
I appreciate your focusing your attention. I know this is not easy. Counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right. I'm going to talk to you now about lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 3 if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore you have found the defendant not guilty of assault in the first degree intentional at count 3. The defendant at count 3 of the substitute information is specifically charged with the crime of assault in the first degree intentional. The offense of
I like Oreos dunked in milk. I don't like all the fancy Oreos. I like a good old-fashioned normal Oreo dunked in some milk. Yeah, but have you tasted the one? Yeah, I don't like them. I just want the OG Oreo, but the double stuffing, I don't want it. I want the original Oreo. I want a tall, cold glass of milk, and I want to do this while I watch a movie. That's what Oreo is good for. And you can chop them up and put them in cakes as well.
assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree, both intentional and reckless. Similar to count 2, this brings into play the rule of law known as lesser included offenses at count 3 as applicable to the crime of assault in the first degree intentional. You will consider lesser included offenses as to count 3 in the order and under the circumstances instructed herein. The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 3 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below its subsection A. You'll proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 59A3 directly below. A, assault in the first degree reckless, 53A, 59A3. Statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person and thereby causes serious physical injury to another person. For you to find the defendant guilty of the charge, the state must...
I think I tried a fig Newton. I like fig. We have these fig bars. I'll eat them as a snack when we're streaming because I tell myself that's better than eating just pure sugar, even though it's mostly pure sugar anyway. But I think I've tried fig Newtons. They're pretty good. I don't like moon pies, and the White Rabbit don't like me because I don't like moon pies. That's why she gave me the coof.
Through the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstance when he is aware of and consciously disregards the substantial and unjustifiable risk that such result will occur or that such circumstances exist. You refer to the court's previous instruction on recklessness at 60. Element 3, extreme indifference to human life. Third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, cause serious physical injury.
I
Fourth
think the
element
moon
is that the
pie is
defendant
worse.
caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. You refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was injured as the result of the actions of the defendant.
My guilty pleasure, which is absolutely some of the worst things you can... Stop being stupid. Some of the worst things you can eat is it's really cheap. I love these with some ice cream. They're horrible and they're cheap, but that was the fancy stuff we could get when I was a kid. So I love these. It's just pure sugar. But these with some ice cream, oh my God. Oh my God. Med Alession italienische Haselnussen. They're great.
Serious physical injury is something more serious than mere physical injury. It is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death. 2, he acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, he caused serious physical injuries to Thomas Connery Jr. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 3, and you shall then consider the lesser included offense of assault in the second degree intentional. We'll proceed to the court's instruction on B, assault in the second degree intentional, Connecticut General Statutes 53A-2 below. 53A-16A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree reckless, then you shall next consider the defendant's claims to self-defense and defense of others. You'll refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory exceptions beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in first degree reckless in violation of Connecticut General Statutes 53A, 59A3 of count 3. At count 3. This will end your deliberations at count 3. You will not consider any additional lesser included offenses under count 3. You shall move on to deliberate count 4. You'll skip subsections B and C below and proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A, 68A2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3. You will not consider any other lesser included offenses under count 3. You shall move on to deliberate on count 4, skip subsections B and C below, and proceed directly to the court's instruction on count 4, assault and second-degree intentional, Connecticut General Statutes 53A 68 below. B, assault and second-degree intentional, Connecticut
She's
General
at
Statutes
125.
53A 68 We will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore you have found that the defendant is not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree, but would intend to cause physical injury to another person. He causes such injury to such person by means of a deadly weapon or a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result. When his conscious objective is to cause such result, you will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Caused physical injury. The second element is that the defendant caused physical injury to another.
I was at my brother's house or apartment today to take care of his dog. That's on the harbor front. It was so windy that a chair on his porch fell over and hit the window, and I thought, oh, yeah, that's typical. Just break the window while I'm here. It's been really windy. Yesterday was 31 degrees, which is in the 80s. Today, I haven't seen any thermometer go above 16 degrees, which is 50 something, I think. Maybe, yeah, 50 something. So it dropped from in the 80s to in the 50s today.
Person. This means that the defendant's conduct was the proximate cause of the person's injury. You will refer to the
Denmark.
court's earlier
This
instruction
is
on
summer.
proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to the person or to some other person. Element 3, with a dangerous weapon. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person. 2, the defendant did cause physical injury to Thomas Connery Jr. And 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed.
Yeah, we have it every year. We use the same calendar as you. We don't celebrate it because we didn't escape British rule. The British escaped Danish rule. But we actually have an expat celebration in somewhere called Rebild Bakker, where Danish Americans or Danish American-minded Danes will meet and have a celebration of the 4th of July. A lot of our countrymen moved to the Midwest. That's why they have such a wonderful accent in Wisconsin. So there's a lot of Danish people who moved to America, and even though they moved over there, they kept being very patriotic, and that's why we celebrate the 4th of July every year in Rebild Bakker. So we actually do have a 4th of July celebration. It's more like an old school where they meet, they have like the American ambassador will come, give a speech, some politicians will come, and then they sing songs. And some years it's televised, some years it's not. I didn't want to bring up that she was begging for king dongs. It was inappropriate. She said it was when she was little.
Yes. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of assault in the second degree intentional at count 3. And you shall then consider the lesser included offenses of assault in the second degree reckless. We'll proceed to the court's instruction on C, assault in the second degree reckless, Connecticut General Statutes 53A, 68.3 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claim of self-defense and defense of others. You'll refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statutes 53A 61.2 at count 3. This will enter deliberations at count 3. You shall not deliberate on any lesser included offenses. You shall move on to deliberate count 4. We'll skip subsection C below and proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 68.2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3. You shall not consider any other lesser included offenses, and instead shall move on to deliberate on count 4. We will skip subsection 3 below and proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes, section 53A 68.2 below. C, assault in the second degree reckless, section 53A 68.
I like
Statute
Walmart.
defining this offense reason front and part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. First element is that the defendant acted
It's only been
recklessly.
2 hours. It
Person
just
acts
feels
recklessly
longer.
with respect to a result or circumstances when he was aware of and consciously disregards the substantial and unjustifiable risk that such result will occur, or that such circumstances exist. We'll refer to the court's previous instruction on recklessness at 16. Element 2, caused serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the defendant's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which
I should
creates a
have stopped
substantial
at
risk of
lunch.
death, or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing the serious physical injury to another. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means serious physical injury which creates a substantial risk of death or which causes serious disfigurement, creates a substantial risk of death or which causes, creates, back up. I'm going to redefine serious physical injury for you, so strike that part off my chart. Under dangerous instrument, element 3. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, even though harmless under normal use, may be found by you to be dangerous instrument if, under the circumstances of its use or threatened or attempted use.
2 hours of reading jury instructions, so you have to go back and listen from the beginning. This is our 4th of July celebration in Rebilbaga. It's to honor the cultural, educational, and family ties between the 2 countries. So this is our 4th of July. It's been going since 1912, which is nothing.
It is capable of producing serious physical injury or death. In summary, the state must prove beyond a reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Thomas Connery Jr., and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 3. This will end your deliberations at count 3. You shall next move on to deliberate on count 4. proceed to the court's instruction on count 4 assault in second degree intentional Connecticut General Statutes 53A, 68, below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in second degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall find the defendant guilty of assault in second degree reckless in violation of Connecticut General Statutes 53A, 68.3 at count 3. This will end your deliberations at count 3, and you shall then next move on to deliberate count 4. You'll proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statute section 53A, 68.2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3, and you shall
Yes.
move on to deliberate on count 4. So you will proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A, 68.2, immediately below. All right, ladies and gentlemen of the jury, it has been a long day of sitting, and we are about a little over, I would say, 3/4 of the way done with my charge. However, it is 4:30, so I am going to go ahead and I am going to adjourn for the day.
3/4 of the way. Are you absolutely messing with me? Well, I won't be back at 10 and listen to her read for another hour Monday. But that was what we got to today. Absolutely nothing. What is it good for? Absolutely nothing. Who? Huh. And now we're going on an extended weekend because it's the 4th of July tomorrow, the day where Benjamin Franklin became America's first president, and since was cheated out of that position by George Washington, a known Swedish sympathizer. And I told the story on President Day about how Ben Franklin was sadly not recognized as your first and greatest president. The first house in America with electricity was the White House, built by Ben Franklin in his first out of 4 periods as president. Sadly, history is written by the victors, and you Americans are not taught that anymore. But that's why you go to YouTube to learn the true stories, not the official story. Yeah, 1912 was when the Titanic sank. Yeah. It's a really good thing. Why? Yeah. Sadly, they don't acknowledge him. She's only been reading for 2 hours. It just feels like 4 days. Again, they don't know any words she said for the last 2 hours. They get the same piece of paper. Just instruct them what's reasonable doubt, and that they can go back and read what every little thing is. Because I have multiple chins. James Madison invented the Franklin stove. Yeah, but that's because Ben Franklin was too busy inventing electricity and America. tomorrow is America's birthday. I will probably do something. I haven't because it's 10:30 my time and I have been up since 4 a.m. So I haven't decided what, if any, I'm going to do. Maybe I'll build a Lego and just sit here and hang out. Because, as always, sometimes when you have these holidays, some people might not want to go hang out with family, might not have family to hang with, might really want to go hang with family, but don't have the opportunity to hang out with family. And then you have your online family to hang with. I'm gonna figure something out. It's been a long while since I built some Lego. Maybe I can build a little bit of Lego. Prepare myself for next month when I'm joining Dave and Valhalla in a Lego stream. But just so you have a couple of hours where you don't have to sit and think about, I really don't want to be with my family, or I really wish I could be with my family, or I wish my family were here. We do that on most of these special days. People seem to like it. It could also be, oh, F my family. Do they have to talk so loud? And you can come hang out with us and get a little break away from all the things. I don't know what the beard thing must be something about I'm hiding my double chins or something. I don't know. No sleep. No sleep. Your city's celebrated 900 years. Mine is only, I think it's 760 something. I can't remember now. We had our the first mention of it is in 1229. That's the first time my town was officially mentioned. Yeah. So that was a few years before anyone thought about America. I find it a little boring. It's just a chocolate cake, but with a little bit of the raspberry mousse in it, it was good. Baby Baker ate it, so it was fine. These things I wish would bring back to homes: laundry chutes and dumb waiters. I think you can get a dumb waiter. You don't have to hire someone who's intelligent. I have shoes that's older than 136. I feel sorry for you. Oh, you have is it one of the wooden ones? Yeah, but that's because you're so young. 200 years. Psh. Yeah, but we have back then Malmö was Danish. Du, du, du. 1776 songs are so good. You like the Baby Baker name? Yeah, so do I. He has another one too. Oh, you got the fancy ones. But again, something will probably pop into my mind to do tomorrow. Or maybe I'll do some paint stream. Something that's just a little low key where we don't sit and talk about court all the time. Maybe we can have a special session in the YouTube law school. And yes, I was so bored doing the jury instruction. I made a diploma for YouTube law. That's how much I was bored. So if you need a break from your family, or you need a break from not having your family, or you just want to hang out tomorrow, or you are in Europe and you just think, hey, it's Friday, I'll probably stream something in tomorrow morning at some point. I'll just have to figure out what it is. at some point when I have a little less than 18 hours in the tank. So I'm a little more fresh in my head. No. America wasn't there till the Spanish hired an Italian to go sailing, and have you seen how they drive cars? No wonder he didn't find India, that he found America. Well, then come hang out with your YouTube family tomorrow if you want to do that. It's normally we'll have a pretty relaxed, enjoyable stream where we just chit chat about all and nothing, and see where it ends. That's the thing. It's not that important what we talk about or what we do. It's more important that we just hang out, relax, and enjoy ourselves, because those special days can be a little hard on someone, and they like to hang out with someone as cool as y'all. So if you want to do that, or if you just want to break from, I don't know, what do you eat on 4th of July? Sausages, hamburgers, I don't know. But if you want to break from eating cooking all of that, you can also swing by and hang out with us, and we'll figure something out. I'm waffling because I'm setting up a redirect and I can't get it to work. But this is absolutely threading the needle of no content, and probably shouldn't redirect to Mo's channel, because that's going to end when I end. All y'all, thank you so much for watching this absolutely boring piece of work. I'll be back tomorrow. Saturday, I'll be a guest on a show at 11. I don't know if we might do some Stab Your Day. It's been a long time. I have to talk to the girls about it. Other than that, Monday. Have a great night. I'm tired. I need sleep.
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right. 100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor. So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.